All right. Hello, everyone, and welcome to another episode of the Bitcoin Law Review. Today is Wednesday, July 29. Can't believe how long it's been since we've done this show. Jason, loving that Star Wars t-shirt. Really
Old
taking
school.
you back. How old were you when you went to watch the first one?
Let's see, 4 or 5 years old in the theater.
I gotcha. And Sasha, of course, wasn't even born yet. Hello, Sasha.
Hey, how's it going?
Good, good. Hey guys,
Thanks for doxing me as an old bastard.
I know. How do you know I wasn't born?
Tone, were you even alive then? I mean, just
maybe. I'm gonna plead the fifth on that one. No, I wasn't alive then. I'm not. I'm old, but I'm not. I'm almost that old. So, hey guys, thank you for joining. And
such a troll, Tone. You're such a troll.
We're gonna have a few more lawyers joining us in a bit, but we are gonna kick off the show. We got a really packed show for you guys today. But before we begin, let's. I mean, you guys are regulars, so you don't even have to introduce yourself, but please do. And just give me or our audience. Give us your general thoughts on what's happening with some of the civil rights stuff that's going on with all the protests. We had a whole show on this last time. It was very unfortunate that we couldn't get, it was literally 4 white guys because I couldn't get anybody else on. Everybody else was busy. But Sasha, would love to get your just general thoughts on the situation as well.
Before we start, I just want to make sure that everybody knows my name is Jimmy Song, and I'm a longtime crypto enthusiast. Happy to be.
All right, Jason, let's go ahead and start with you because you were on that show with was you, myself, David Silver, and Bill Restus. Hopefully, Bill will be joining us a little bit later. I haven't heard from Silver in a couple of days. Hope he's all right, or a couple of months actually.
I talked to him this morning. He's busy. But he's doing good.
Okay. So go ahead, do a very brief intro. Tell us, give us like a little update on what's going on with the quarantine in your area, and
Sure.
then we'll get into what you are up to these days.
Sure. So my name is Jason Seibert. I'm a crypto securities lawyer. Prior to law, I was a data engineer trained by the military. One of the few folks that's actually a data engineer and no securities law. So I think I've been doing this just about as long as anybody else in the field. For those of you that don't know me, hi. Lately in quarantine, I've been playing my guitar, trying to channel my inner Jimmy Song. And I've been following the protests in Portland, which is where I was raised, and actually the Hatfield Courthouse, which has been attempted to be burned down for the last couple months, is the first federal courthouse I was ever sworn into. And so I've been following those events pretty closely, watching, the behavior of the rioters versus the behavior of the federal protective services and how they're antagonizing each other, trying to stay neutral from the libertarian centrist position that I hold instead of being judgmental on either side. And I got to tell you, there's some interesting things going on in Portland, so much so that I contemplated driving back there from Houston to become an official legal observer just to really try to set the record straight, but haven't done that yet. Maybe I will. So anyway, that wasn't necessarily a short introduction, but I've never known myself not to be loquacious. So sorry.
Hi. Yeah, thanks, Jason. I'll be very interested to hear your take more on on the civil rights stuff. I just moved to Florida from DC. We kind of took the opposite approach. We wanted to get out of the crossfire of the protests and whatnot, and we're here. My husband and I are here in Jacksonville, Florida, and it almost feels like there's nothing wrong in the world here. Like there is a mask mandate, so you do have to wear masks when you go in the stores, but other than that, everything's open, and life is continuing as normal. And professionally, I work for DLT Law Group, been doing that. I think it's coming up on 3 years. And before law school, I was a licensed Series 7 trader with TD Ameritrade and worked a number of different institutional sales and banking. So Yeah, happy to be here. I guess so. Like you said, we're regulars on the show, so we've been introduced a few times, but we haven't. I haven't been on this show. I think the last time was in March or something. So
Well,
yeah.
you had an accident. Are you better? You're healed up? We were
Yeah,
all
I have a lot of
genuinely
makeup
concerned for
on.
you.
My face a few weeks ago looked pretty grotesque, but yeah, I fell on the side of my face off my bike, and I broke actually 5 bones around my eye socket and like jaw. So it was pretty bad, and I'm
Well,
pregnant too, so
oh my
so
goodness.
it was super scary having
Congratulations.
that happen.
It's
Yeah,
awesome.
Oh yeah.
I
Thanks.
wasn't sure if Sasha wanted Doc to be doxxed around the world.
I put it
But
out there now.
how how fast were you going on your bike when that happened?
It's the whole thing was really stupid on my, like, it was just, I was testing the bike. I was just on a sidewalk outside the store, and it was one of these beach cruisers, and I'm used to my triathlon bike that has the
Hmm.
brakes up front and is quite fast, and this thing
Hmm.
was just all slow and clunky, and the brakes were on the pedals. And I just went over this. I was trying to see, I felt like, oh, I'm not going to be able to get any workout on this thing. Like, it's just too slow. So I went as fast as I could, and then when I came up on this dip, like for grocery carts or something, I just braked too hard with the pedals. Like, I should have done it softer to slow down a bit, but it stopped me immediately, and I just
Oh,
Yeah.
went over the handlebars. So it was not the smartest thing for an expecting lady to be doing.
Right.
But
Well, not to share too much, but when I was 15, I had a bicycle accident where I went over the handlebars, and a lot of people ask me about the scars on my face. I had 60 stitches to actually put me
oh
back together
God.
again, and lost a tooth and everything else.
Mhm.
But when they were putting me back together when I was 15, they said, "Don't worry about it. When you're older, the scars will blend in with your wrinkles." And when you're 15, that's not something you want to hear.
No.
But I'm happy that
Like,
I didn't need it
I can't
reconstructed.
believe you guys got that hurt. Like, I remember when I was like 10 or something, I also went over the handlebars completely,
Yeah.
but I kind of just got up and walked away. I didn't have any kind of like serious damage. But yeah.
So let's, while we're waiting for maybe one or two other lawyers to jump in, do we want to talk about the conflation of BLM protesters and
Yeah,
anti-fraud violence?
Yeah, well, like, I don't know
And
if
maybe
you,
give some, what I would like to do is give the viewers maybe some guidelines that if they do want to go and participate in some of these events, what their rights are and how not to cross the line. I'd like to try to couch that in that and maybe give some heads up to folks that.
yeah, go for it. Though I highly doubt there are many viewers of this channel that are out there in this protest. But yes.
Excuse me, the crypto anarchists that frequent the programs and believe that cryptocurrency is the solution for government control. You don't think that there's one or two guys out there protesting that have a few coin in their pocket? Of
I don't
course
think
there
so.
are. I think.
I heard
And
it's
that's,
spiking. I heard Bitcoin use is spiking in Portland lately, like when they're looking at its various charts for peer-to-peer transactions.
yeah, I wouldn't doubt that. So the first thing that I want to talk about, and I've handled plenty of civil rights cases on the pro bono panel in that very same Hatfield federal court, is that when you're exercising a constitutional right, that constitutional right can only be exercised so far as that it doesn't infringe upon somebody else's right. And that's kind of the umbrella that you need to look at. So you can exercise free speech all day long and twice on Sunday in a public place, in a public forum, and a government actor is not allowed to attempt to suppress that speech, so long as you're doing that under the confines of protected speech. The moment your speech translates to violence or you incite violence, your speech is no longer protected. And that's the legal standard of free speech. There is no such thing in United States jurisprudence as hate speech. You can call somebody names all day long that are offensive all day long, etc. All of that is protected as free speech. However, if you say that so-and-so needs to die and you need to kill that so-and-so, now you've crossed over, because those are words that tend to incite violence. So that's one of the distinctions of free speech and civil rights.
And Jason, is that kind of like that St. Louis couple that was the woman was pointing the gun at the protesters, even though the protesters had crossed onto private property in the home owner association or whatever, they jumped a gate, but
well,
is that the same kind of thing, because she was pointing it, so it was kind of elevating the risk of violence? Or
well, that's an interesting scenario where that depends on the interpretation of the local state law, and that has nothing to do with free speech from the people pointing the guns standpoint. The people that were protesting and had gone onto private property, they no longer have free speech rights when they're on private property. When you're on private property and you're attempting to speech, now you're trespassing, especially if you've been asked to leave. Once you're asked to leave a location that you're not entitled to be, you don't have free speech rights. There's no constitutional rights to protect you to be there unless you have a right to be there. So crossing into somebody's home or into non-public areas and then saying, but it's free speech, that's not protected. You're trespassing. Now the respondents, the husband and wife that were holding the guns, depending upon the interpretation of gun laws in that state, whether or not Castle doctrine applies or not, and where that line is, may or may not have required that couple to actually have to retreat behind their doors before being able to use deadly force. In some jurisdictions like Texas, somebody comes onto your land and doesn't leave, they don't have to come inside your house. You don't have to retreat inside your house. They're on your land, they're threatening you. You're not to be insensitive, but it's kind of an open season moment at that point. You're allowed to defend yourselves. In some jurisdictions, your being in your car with no ability to leave your car gives you the right to defend yourself. And we saw an example of that in Austin, when a protester trying to exercise free speech rights, wanting to defend his free speech rights with an AK-47 over his shoulder, walking through downtown Austin, stopped a car and pointed his gun at the window of the car. I don't know if you've been to Texas or not, but there's a lot of Second Amendment, right? Supporters here. The guy inside the car, when seeing a gun pointed at him and he had nowhere to go and felt threatened, pulled up his gun and shot the guy. That's one of those deals of now we're talking about various rights that have to be examined moment by moment to determine whose right was infringed when. Because certainly in Texas, you can absolutely carry a long gun out in public, and that's your right to do that. But he crossed that line of that right to do that when he raised that rifle and impeded somebody else's rights to be secure in their persons. So when looking at the right to protest in Portland specifically, absolutely they have the right to protest. Now, that is tempered by certain provisions where the city, if you're going to protest on city blocks or city properties, you're supposed to get a permit to do that. You're supposed to apply ahead of time to do that. You're supposed to request permission to take over those spaces that are otherwise able to be used by other people in the city, right? These are public thoroughfares. You're blocking them off or impeding traffic. You want the ability to do that, you have to request the permission of the government to be able to do that. However, Portland is not requiring that of these protesters because there is no clear organization of who would actually apply for that. So this is kind of a grassroots movement, and I like that. I like a grassroots free speech movement. Now we cross the line when people go into that free speech protected protest movement with the intent to incite or create violence. The intent to incite or create violence is not a free speech protected component. And so the behavior of the rioters that are, going around the block, taking a plastic grocery bag, shitting in it and throwing it over the fence after lighting it on fire, that's not protected speech. Throwing strollers over, throwing carriages, lighting fires and burning things, trying to burn down trees within the fence line to get the officers to come out to put out the fire because the fire department can't respond, trying to light things on fire so the protective services has to come out in order to prevent the fire from lighting the building on fire as an ambush technique, so that once these guys come out, now they're getting lasers shined at them, they're getting bricks thrown at them, they're getting bags of shit thrown at them, all these terrible things just to try to protect the property. And I was able to tune into a live broadcast like last night that was being streamed, and I witnessed all of this stuff without the media filter, and it was very interesting to see the tactics that were being done on either side, and to examine these things. And the press is right in the middle of it, and I don't know if the press is providing a venue for the rioters to want to do more because they have an audience. Or I don't know. So it's very complicated, but getting back to your rights, protected free speech to protest is there as a constitutional right. But the moment you try to get somebody else to do violence or you do violence yourself, that constitutional protection stops. Now let's look at the other side, right? The federal protective services violating other people's rights by unreasonable search and seizure or violence or things along those lines. That's not okay either, but each circumstance has to be examined. The Navy guy that got beat with a stick, right? We all saw it on TV. We don't know if he was actually on federal property at that time and was trespassing and asked to leave. But we don't know that. We don't know those circumstances. It's not being reported exactly where he was. Even still, if he was on federal property, was asked to leave, refused to leave, is trespassing. I don't think that's grounds to beat somebody to the point to where their bones get broken. I think that's grounds for that person being arrested and charged with trespassing on federal property and failure to obey a lawful order. Perfectly reasonable. However, the complication here is the jails where that person would be booked are controlled by the Portland police, which are not cooperating with the federal government in order to enforce the laws. So you really have this tinderbox scenario of just a bad situation that escalates worse because of the restrictions and limitations that are being put on the place based on politics, unnecessary politics that are there. Sorry, I've been going for a long time.
Yeah, I do want to jump onto the crypto side of things, unless Sasha, you want to say something real quick, and then we're actually going to talk about crypto law going forward.
Tone, before we jump out, and after Sasha has comments, I'd be happy to take one or two questions from the group if there's anybody that has a specific important question that isn't a troll question.
I haven't seen any questions, at least none of the questions that relate to law. People are asking me questions as if I'm doing like a Bitcoin trading show. But no. So
what about that one where they say Antifa aren't anarchists? They call themselves that, but they just want their communist goons in power. What do you think of that? That's kind of my thoughts on the whole thing.
I mean, I generally agree.
So if we look at the true definition of an anarchist, and the way I like to look at it is an anarchist is not out to take somebody else's property. An anarchist is not out to hurt somebody else in a true anarchist form. An anarchist goes fishing without a fishing license because an anarchist believes that they shouldn't have to have a license to go catch a fish. That's anarchy. Right? In its pure original definition form, which is the belief that government should exist. Antifa, calling themselves anti-fascist, is not an anarchist movement because they believe in controlling other people and controlling themselves in order to bring about their message. So from a pure definition of anarchist versus behavior and actions of Antifa, I would not say that they're anarchists. What I would say is Antifa is ironic because they actually carry out fascist tactics and ideology in order to obtain their goal. When looking at it just from a strict observationalist and definition standpoint, and maybe that makes me unpopular in the group, but that's just, I'm always unpopular in the group. So. All right, anything else?
No, nothing really from the live chat. Sasha, you have anything to add? Otherwise, we're gonna jump into screen share.
Yeah, I'm good on that too.
All right. So Jason, we're going back to you because as part of your intro, you wrote a blog post. I don't think you write all that often because you are in the middle and really following the court decision in the Liu case. And I had to look this case up, and it was basically, it had to do with how much the government and SEC have the ability to confiscate within these ICOs. So this case seems to, really, I guess, stick it to you. So what are you doing about it?
Well, the Liu case was intriguing in that it really is one of the few times this year that the Supreme Court has stood in solidarity in an 8-to-1 decision. And in law, when the Supreme Court speaks 8-to-1, this is a big moment, right? And what you have here is the court analyzing the SEC's civil action against a defendant where they request injunctive relief for failure to register and for offering fraudulent securities, but also ask for penalties and this key component called disgorgement. The disgorgement, as described by the SEC in all of their actions, is that the defendant who has committed this fraud should not be able to keep their ill-gotten gains, because they're supposed to be removing any of the money that this fraudulent actor took. And what the SEC does is says, you're fraudulent, you're a bad actor, you don't deserve to keep your money, so we're going to take it. And that's called disgorgement. Now, what's happened here is that in Liu, which was a Ninth Circuit case out of California, the defendant said, well, hold on. If you're going to take ill-gotten gains, you can't take everything that I raised because not everything was ill-gotten. And if you're doing that, you're actually taking more than what's equitable, because disgorgement should be an equitable remedy, not a penalty. If it's a penalty, that's fine. But if it's actually disgorgement, you have to take a look at this differently. So what the Supreme Court said is that they agreed with Liu. They said that the SEC is not entitled to receive funds from a defendant that were not ill-gotten. Right? That's big, because what's happened in the past for the last 40 years or so is that the SEC has used this tool of disgorgement for the benefit of the investors to say that they're going to take all the money that was raised, they're going to hold on to it, and they're going to, quote, distribute it to the investors on behalf of the investors. But what does the SEC do with that money? They don't give it to the investors. They put it in their own war chest. They put it in their supply of funds to pay out whistleblowers. They put it into the treasury. And the reason they say that they don't distribute it to the investors, what they said is that they don't always collect the money. But really what it is, I don't think that they always know who the investors are. So what you get, and if you take, for example, and I'm going to bring this back to a cryptocurrency case, right? Let's take it back to SEC v. Shavers. The SEC disgorged Shavers in a judgment of all the funds that he raised. Now, if you take a look at the funds that Shavers raised, it was around 4 million-ish in present day funds in Bitcoin, right? Now, they brought that case almost 2 years later, and when they got their judgment, because the price of Bitcoin had gone up, they actually got a disgorgement award for over $40 million, because that was the present day value of Bitcoin, not what he actually had or what was distributed at the time. So the SEC got a disgorgement award for $40 million, which is $36 million more than Shavers actually received in Bitcoin, because that was a disgorgement award. I'm sorry?
He clearly didn't have $40 million worth of Bitcoin at the time to give back to them. So what the hell happened?
Correct. So this is the equitable argument of in Liu that presents, and the Supreme Court agrees. The Supreme Court says here the SEC cannot take more than was ill-gotten. And it's a very narrow reading in Liu, because what was raised in Liu is that the defendant said, I have reasonable business expenses. You have to allow me to give an accounting, and you have to deduct these reasonable business expenses of money that we put into it away from the funds that were raised. And so that's a very specific issue. Now, if you carry Liu to its natural consequence, an ICO that say raised $25 million, and they do so by distributing a white paper, and maybe they make a couple of tweets, and they raise 25 million, and the SEC comes along and says, all of that's fraudulent, so every single thing that you raised has to be disgorged. Well, the way that I read this case is, hold on. You have to prove that that was ill-gotten. You can't just say that one thing, one statement caused every single person to purchase that security. So in a normal private litigation between a plaintiff and a defendant for securities fraud, that plaintiff would have to say, I purchased this security on this date, I spent this much money, I got these many securities, I relied on these statements which were made on these days. Okay, and that's the analysis. You told me this, I relied on that, as a result, I purchased it, it was fraudulent, I want my money back. The SEC doesn't have to prove when they get disgorgement in the past that anybody relied on anything that was said. Think about that. That's insane. Right? How many people participate in ICOs, not because they read a white paper? Who reads white papers anymore? Nobody does, right?
No. Most people participate in ICOs because some guy with a frog as a picture on Twitter is telling them they're going to make money.
Yes, and they don't even look at the tweets that come out from it. They just go and they participate in the ICO. So the point here is that if I was a defendant and a plaintiff came to me and said, I bought 2,000 SHIB tokens on June 1st, and it turns out you're a scam, I want my money back, I would be able to say, great, you bought it on June 1st. What statements did you rely on that were fraudulent when you purchased that you're claiming you relied on to make that purchase? And they would say, well, I talked to my buddy at the bar. So you relied on your buddy at the bar, not me. You didn't rely on my statements. I didn't commit fraud. You're not entitled to your money back. That's equity, right? That's an equitable decision that reliance is necessary to make sure that if a defendant is going to be separated from their money for ill-gotten gains, the gains have to be ill-gotten. Does that make sense? So,
I mean, it does make sense, and I wish, like, basically, it makes sense, but it also means that a lot of these ICO scammers are going to get away with a lot.
No, what this means is the SEC actually has to do their work. See, in the picture this, okay? The SEC will do an investigation for 1.5 to 2 years before they actually file a complaint. In that 1 to 2 years, they should know everybody that purchased. They should know who they are.
Well, not in crypto, because you buy anonymously.
Not everybody does, right?
Not everybody
does. Take Tezos, for example, right? Everybody that collected Tezos had to register an AML KYC. They have that information.
Yep.
And what's interesting in the Tezos case, if you remember, what was his name?
Brightman?
No, the original plaintiff in the class action.
Oh, I don't remember the name of the original plaintiff now.
Mendoza, right?
Okay, right.
Right. So what Mendoza even admitted when he gave his deposition was that he actually never relied or read the white paper or read any of those things before he purchased. That's critical. He wouldn't qualify as a private litigator to be able to bring those cases. So what Lou says in a nutshell is disgorgement is no longer carte blanche, the ability of the SEC to just take everything. They have to actually show that the funds that were obtained were ill-gotten. Now, how does this relate to utility token offerings? Right? Now, Sasha, do you remember the securities case that talks about use? Anything that you use for personal use or consumption is not a security. Do you remember the name of that case?
Shoot, I don't remember it offhand, but it's from the United States Housing versus Foreman.
Yes, excellent.
That's the Foreman case. Yeah,
That's the Foreman case.
It's always up on. Oh no, not that one. Sorry, it's always up here somewhere. I have too many tabs, but one of them is the Foreman case.
Right. We've talked about Foreman quite a bit in the discussion of utility tokens, and that.
Oh,
perfect. Thank you. So the Foreman case is about housing and investments and sub-investments, et cetera. And ultimately, what the court says is it's not about what it was called, whether it was called an investment or this, that, or the other. It's ultimately about the content of the transaction that occurred. And the content of the transaction that occurred here is that these people bought these homes to live in them and use them. And because they're living in them and using them, it can't be an investment contract because they're using it. And any investment contract for use is not an investment contract, ergo not a security. The SEC doesn't have jurisdiction, blah, 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 blah. So when we look at the analysis of utility tokens, where maybe there's some content or there's some tokens that are purchased for investment, but that project actually has a working platform that does offer products. The SEC, I would argue, can no longer say that all of the tokens sold for investment and products, they can no longer argue that all of those should be disgorged, because the ones that are purchased for product are not ill-gotten, for one, right? These aren't ill-gotten gains. These are legitimate business transactions, not for investment. So we have not ill-gotten, it's not equitable, and two, Foreman applies. So if you're defending one of these cases, one, you would have to show that Foreman applies, that it's actually being used. And then two, you would have to say that all of those funds should be excluded from a disgorgement calculation under an accounting and excluded under equitable principles per SEC v. Lieu. So you use United Housing and Lieu in a utility token offering in order to exclude or isolate any type of an investment or fraudulent investment that may have been made there by saying this is the greatest token ever, and you know, if you buy this token, you're going to shit rainbows, right? We know this is a fraudulent statement. Make up whatever fraudulent statement you want. But people that bought the token in order to use the Rainbow app that has use on a phone, those sales should be excluded from a disgorgement.
So Jason, so
really what we're talking about is the ultimate damages at the end that the SEC can collect.
Look, so here's my big problem with it, and this is why, like, if these ICOs end up with good lawyers, they'll probably get away with it. So what you do is you sell all of your ICO tokens in the beginning under KYC to a bunch of small number of people. And it doesn't really matter what you promised them, as long as those people agree that they are buying this token for usage. And as long as all those people sell it on the secondary market, you know.
You're talking about Telegram at this point, and the court ruled correctly on Telegram.
Jason, let me finish. So you start an ICO. So here's how you scam a bunch of people. You start an ICO, you sell it to a small group of people under the fact that it's going to be usable for something. All those people get in early, and then they resell it on the secondary market to a bunch of random people. And as long as the company no longer says the ICO company no longer mentions their own token after the fact, then it ends up on a secondary market before or after the platform is ever built. And boom, you are completely in the clear. You sold a bunch of tokens to qualified investors that promised to buy it for usage. They then resold it to a bunch of bag holders on the secondary market anonymously that they can buy it. And then nobody from that second wave of people that bought it before it dumped can sue you because they weren't the original buyers of the token, and they didn't buy it because of your recommendation. They bought it because some frog on Twitter told them it'll go up.
There, though. The Rule 144, those people that buy it as accredited investors can't turn around and sell it until the company has removed their, security basically they have to almost take the thing public to remove the restrictions.
No,
of
but
Rule
they're not
144.
securities. But that's the thing. These
So
things.
Tone, what
But if
you're
they're sold to
describing
accredited
is
investors,
exactly the end around that Telegram tried to take. And the court saw through that and decided correctly on that. Because remember,
but how come they still? But this is my problem. Why did they see it through Telegram and not through 1,000 other shit coins on CoinMarket?
Because Telegram registered as a security initially, whereas a lot of the other ones are not registered as a security initially, and they're just selling to anonymous people who give them Bitcoin or Ethereum.
So basically, Telegram fucked up.
Telegram tried to comply with the rules, where most of these people just start off not complying, and that's how they got away with it.
So don't comply from the beginning, and you have a chance to get away with it.
You have a pretty good chance, because look, there's only like 20 companies that have, thousands that did ICOs that have been charged.
So this is a good transition. So let's talk about a few ICOs that did not register with the SEC, wanted to get away with it, but actually got caught. And of course,
this title is why this website provider is just the worst. They were not sentenced yet. No one's been sentenced to 7 years.
Let's not. We can have a whole other show about the shittiest reporting in the world that takes place on crypto companies.
Cointelegraph.
Well, it doesn't matter if it's Cointelegraph. I mean, CoinDesk is no better. I've seen just as shitty reporting on CoinDesk. So this is just a headline. But we're going to go straight to the actual, the official statement. Co-founder of cryptocurrency company pleads guilty for role in the ICO fraud scheme. Okay, so we are talking about Mr. Robert Joseph Franks, who pled guilty for Centra Tech. That was the ICO. And clearly he never launched a product. The reason why I still have like the Cointelegraph thing is because they give a little bit more detail on the shitcoin itself. So this happened to be the same one that they paid DJ Khaled and Floyd Mayweather to promote, and the SEC nailed them as well. Now this was supposed to be a Bitcoin debit card, which never actually launched, unlike the Monaco card, which actually did launch. Otherwise, I would have loved to see the same thing happen to Crypto.com, which has 2 scam coins, not just one, crypto token and the Monaco token. And it was basically the same product, but one made it to market, one didn't make it to market. And by not making it to market, these guys got nailed for running ICO fraud. So I guess, Sasha, you want to comment on this first?
Sure. Yeah, I remember when this case first came out. The facts were just so shockingly bad against the co-founders of the company. They made up this Michael Edwards guy. They had all kinds of people made up on their team page, fake LinkedIn profiles, and it was just a clearly fraud. They had no intention. It doesn't seem like of executing on anything with their ICO. The shocking part was that they still had quite a bit of money saved in their bank account, so that it was able to be seized. And then, I just saw a comment. I don't know why someone would say that, but I'm not high as fuck right now. So
well, it's only because you're some amazing pain. That's all. And we wouldn't fault you. You had an accident.
But I'm not. I don't do any drugs.
Before you actually care about comments, always look at the name of the person commenting, and that should tell you a lot whether you should take that comment seriously.
True. But anyway, I just thought I'd put it out there. I have a strict no drug policy for myself, especially while pregnant. So anyway, but yeah, so he did plead guilty. The maximum sentence carries 10 years, jail time, but the sentencing hasn't happened yet. So we'll have to stay tuned, but he probably will be going to jail for some, length of time anyway.
So what folks need to see behind the lines when they read that somebody has pled guilty is to understand that they've got to a point to where they do not want to fight the charges anymore. And so criminal defendants will plead guilty to things that they normally wouldn't plead guilty to, simply to be done because they can get a better deal or they see a road out. I'm going to bring back the Shavers case again. After the civil lawsuit with the SEC, and after that was concluded, he walked out the doors and right into handcuffs, and was tried in the Southern District of New York for, securities fraud at a criminal level. And even though we could show through blockchain evidence that Shavers had returned 99.9% of the funds that people claimed were lost, the only thing he could afford, because the SEC had frozen all of his assets, was a public defender in New York. And the public defender couldn't afford to hire experts to bring in to explain how the blockchain works, this, that, or the other. And the PD walked in and said, look, I can get you a year and a half in a nice white collar federal prison, Camp Texarkana. It's got a golf course. Plead guilty and you'll be out in a year on good behavior and we're done. And even though Shavers absolutely had defenses, he was looking at another year to 2 years of trial and appeal where he has to sit in jail the entire time during that trial and appeal, or he could just plead guilty and do the same amount of time of jail and get out. And so a lot of times when you see, somebody's pled guilty, it doesn't mean, and this is just me putting on my defense lawyer hat for a second, it doesn't mean that they're guilty of sin. Clearly there were some things that went wrong here, but I don't think the crypto community should ostracize everyone just because they took a strategic choice. So anyway, that's my only soapbox on the criminal justice system as it may relate to how it applies for our earlier conversation in protesting civil rights. So,
how much time did Shavers do?
I think it was a little over a year before he was released to in-home probation, ankle thing. So but after
he got out like 2017 then, right? 2017, 2018 he got out?
Yeah, I don't have the exact date. When I exited the case in Texas, I had very minimal interaction with Mr. Shavers. I did attempt to contact his public defender in New York to offer assistance, but the PD didn't want to return my calls. And so, I went to visit him a few times in Arkansas, in Texarkana, in prison, and one thing that prison did for him is he lost a lot of weight. He came out of there fairly healthy, and he learned how to use herring as money. So, yeah.
All right, so let's stick with similar situations, and once again, we have another ICO scam, PlexCoin. That they have just been charged with fraud. I have to go through the articles. I have to remind myself what the hell these ICOs were actually supposed to do. So this is 3 Canadians that for God knows what reason were living in the US, allowing the US authorities to grab them. And ironically, this was part of a settlement that they had with the SEC a little while back. But now they were arrested and charged criminally. So here is so here's the case. So this is the recent arrest of the 3 people, and this was their settlement with the SEC earlier this year. Oh no, that's a different one. Where is I think this is the settlement. Sorry, guys.
They had to pay back, I think it was like $4.5 million.
Disgorgement.
Yeah.
So it was kind of like what you were talking about. I think they raised $8 million. So they only had to pay back 55% of what they raised, but they probably thought, well, I don't know, maybe they knew that this was coming, but I thought they were done after the SEC thing, and then here they get whacked again with the criminal charges.
So
Right.
we talked.
Go for it.
We talked about this a little bit earlier in our side lawyer Telegram chat, in that the SEC does not stop an action simply by having a judgment there. If you're a defendant in a securities action, you are a defendant at the state level for state administrative, state civil, state criminal, and federal administrative, civil, criminal, and for any potential plaintiff that may have a claim against you. So you're really fighting on, 4 to 7 different arenas at any point in time for one issue, and double jeopardy doesn't apply to any of them. And so that's where securities law is very difficult for a defense attorney to make sure that they strategize and take advantage of all the potential, or avoiding potential pitfalls that exist, and understanding that the very moment that here an ICO offeror gets a letter from an administrative agency, the SEC, they need to instantly start defending against imprisonment, because the SEC takes all of their stuff that they get from subpoena and they just hand it right over to the DOJ. They're just sharing files all day long. Everything you say. You go in for an informational interview with the SEC because they just want to find out what's going on. There's no criminal charges against you. They're not filing a complaint. It's under oath. They take the transcript and they hand it right over to the deputy district attorney that works alongside them. And they start building their case at the same time. So key to understand when you're going to do these things or make any offerings, or if you get a letter from an administrator, is you really need to start planning for, okay, how long do I want to spend in jail? And your lawyer needs to help you figure that out right from the beginning, not after the SEC case is done.
So what does this mean for the pitiful settlement that EOS did with the regulators, where they charged them like 0.0003% of how much they raised? Does that mean that there could still be an actual hammer coming down on EOS?
Do you have that settlement up? I can't remember if that settlement included allegations of fraud.
Yeah, because
I don't remember. Let me see. It's around here.
So I think part of what these guys did was they said investors could expect returns up to 1,354% within.
Well, that's these guys.
Days.
That's these guys. I wish.
I know, but that's what led them to get nailed here. And then they spent the money, on boats and houses. So I don't think EOS would be that stupid, and I think they weren't charged with the fraud because they didn't do things like that.
Right.
Oh.
So when you have unlicensed, unregistered securities, that usually doesn't carry a criminal component to it, right? That's a fine, that's potential disgorgement. Hell, it's unlicensed and there's no fraud. The SEC may even allow you to do what's called a rescission offering and get into compliance and come into the fold and welcome to the family. But when you commit fraud, the SEC will build the case as hard as they can, and then hand it right over to the DOJ. And if the SEC gets any kind of settlement agreement with you where you're admitting that you committed fraud, well, that's prima facie evidence right for a grand jury to put you into handcuffs in a criminal complaint. See, they admitted they committed fraud. So that's when an attorney is making a settlement for you in a securities action and you're in the civil side, the key phrase of, the defendants do not admit or deny the allegations, but in the interests of resolving litigation have agreed to settle this case under these circumstances. And that's how the agreement should read without allowing any kind of admission of fraud to exist.
Well, I'm reading the SEC statement on EOS, and I mean, they don't really state anything really. It's Block 1 did not provide ICO investors the information they were entitled to as participants in a security offering. And then right here, the SEC order finds that the Block 1 violated registration provisions of the federal securities laws and requires it to pay $24 million. Block 1 consented to the order without
read the last sentence. There it is.
Findings. Yep. So there.
Right. But if you look at that, the SEC's order finds Block 1 violated the registration provisions. The SEC's order doesn't say that they committed fraud. They say in all of these activities they omitted material statements, right? But that's not fraud.
Well,
omission can be fraud, but
it's possible for them to bring charges at a future date.
If it's discovered that there were materially misrepresented statements that were new, that were unknown. Otherwise, all the statements or all the actions that were brought that are a part of this case for the activities, the SEC is basically foreclosed on unless it's shown that EOS withheld information. Now, this still doesn't foreclose the DOJ from bringing an action. The DOJ can still continue to move forward if they like. An SEC action has no bearing on what a criminal case does. However, an SEC action that gets you to admit or finds that you've committed fraud just makes a DOJ action all that easier. Does that make sense?
No, it does. It does. People already talking about Brock Pierce, who was involved in Block 1. Brock Pierce does come up later on if we get to that story, because Brock Pierce is, of course, running for president, and Brock Pierce's name is now coming up because he was one of the original people involved in the Tether creation. And there is more news coming out on Tether. But let's finish up the security side of this program. We have one last story on the security side before we move on to the money transmission side, and that is Abra. So I've been, critical of Abra going back a good years. I don't know when the hell they started, but pretty much since they started. So Abra has pivoted time and time again. They started out as a remittance platform, and that was like I'm sorry. They started out as like a local Bitcoins competitor, and that was silly. And then they became more of a remittance play, and that was even stupider. And then they decided to get into unregistered swap contracts, and the SEC nailed them for that, for offering unregistered security-based swap transactions, which is insane considering the SEC shut down one broker, which was doing exactly the same thing years ago. It's like nobody learns. So this was the one broker case where they were offering people the ability to trade, for example, Apple stock and Netflix stock and gold and silver and FX by basically being the other side of the trade. So if you think Apple stock is going to go up, you put up your Bitcoin leveraged or unleveraged, and you have exposure to Apple stock, and the one broker company takes the opposite side of the trade. And the SEC just completely shut them down. And it was, so what they did was they basically sent an undercover agent to register and start trading on one broker, and there goes one broker. So to me, as I've read the details of what happened in the Abra case, it seems unreasonably similar, what happened there. So I don't know, Sasha, you up to date on this story?
Yeah. It does seem pretty similar. I think Abra was saying I think they had U.S. customers, and then they got a notice from the SEC sometime in 2018 or 19, and then they stopped having U.S. customers, but they were still a U.S.-based company. So I think Jason's, very well versed on the jurisdictional issues, but even if you're not selling to the U.S. people, the fact your company is doing business in the U.S., I think, still gives them some jurisdiction. And
international shoe, Sasha. It's international shoe. Such minimum contacts as not to offend traditional notions of fair play and substantial justice. That's the key test there.
Mm-hmm. And so it's, again, kind of a situation here where they weren't actually charged with fraud. They're just violating, they're not registered as a securities broker, or they're selling things not on a registered platform. With the CFTC, they're doing off-exchange swaps, which is illegal. And they had two companies, Abra and Plutus. They each both settled suits for 150,000. Didn't admit or deny accusations, but they've raised 45 million. You know, they had even Stellar, I think, invested 5 million into Abra just last May, and they got a PPP loan somewhere in the range of 350,000 to $1 million. So, you know, their PPP loan covers this, you know, fine that they were, you know, assessed here. So it's not, I don't think it's not gonna hurt them too bad. It's just an annoyance at this point. But yeah.
Right. Let me throw. As far as I know, Abra does not have an ICO scam token, so at least they're not scamming anybody. But it's just a company that has like no business, as far as I'm concerned. Like they keep trying to come up with a business. They have a very charismatic CEO that is able to raise money, but like I don't understand how people continue to give money to this company, because like they keep pivoting to a completely different business, and none of them ever make any sense.
Well, Tone, before you perseverate on that, I want to point out in this case, and it's something that a lot of folks don't think about. This is an SEC settlement release, but this company also came to a settlement with the CFTC. Did you see that in the story?
Yeah, right down there.
Right, in a parallel action. That means if you're doing these types of things, it's not just one regulator that you have to worry about. You have multiple regulators that can come after you for the same conduct. Okay, and a lot of folks,
we just kind of messed up.
It's not. They're different rules.
Well, if they're going to demand the same disgorgement, I can't even pronounce the word, right?
No. They didn't get disgorgement here. These are penalties.
No, I know. But in some cases, like there have been instances where the SEC and the CFTC demand all of your money and you have to pay them both.
No. So after lieu, that's not allowed. And actually, there were a few cases prior to that said if one person got X percentage of payment of disgorgement, that forecloses somebody else from doing that. So for example, if the SEC disgorges you entirely of $1 million, and I want you to think about this, the SEC gets $1 million from you because that's all you raised, and you give it back. Somehow you're able to produce $1 million and give it to them. Now, a plaintiff, somebody who was actually harmed, who was living under a rock for the past 2 years, comes forward and says, wait a minute, you defrauded me, I want my money back. And they file a complaint against you for fraud, asking for disgorgement. You know what you get to say as the defendant? You're not entitled to that relief. I disgorged to the SEC. Go after the SEC for your money. And you know what the SEC's done with that money? They put it in the treasury and they gave it to a whistleblower. Yeah, that's how the SEC works, right? So after lieu, hopefully that changes, because one of the key provisions in lieu, the Supreme Court 8-1 said, funds recovered in disgorgement are for the benefit of the investors, which means the SEC's got to know who they're giving the money to, and they can't just take money indiscriminately.
I have a chart. It's not up to date right now. I think the last time I updated it was the end of 2019, but it tracks all the different disgorgement fees. But yeah, I wonder, Jason, like, so when did lieu come into play? Because what do they do with all the disgorgements that they've already got in their bank account?
Great question. And, you know, I've been in conversation in this action that I'm involved in California with SEC trial counsel there. And what's interesting is I don't think the ramifications of lieu have really trickled all the way down to the field level. I think the commission itself is trying to figure out what this means and what they're supposed to do about it. It's still too early because lieu is so new. You know, I don't think that they even know how to do a proper accounting of the funds. This would be interesting, right? For the SEC to actually have to provide a verified accounting of funds received from disgorgement,
Yeah, that'd be
right?
nice.
right? Wouldn't that
They
be
must
something?
have to keep track of it somewhere. It must go
Right.
into some, you know.
Well, the funds go generally, as the SEC admitted to the Supreme Court in lieu, the funds go either into the general fund to pay out whistleblowers or to go to the Treasury. And and the Supreme Court in dicta, right? So not in a true order, but in dicta said, if we read the letter of the statute that gives you equitable remedies for, you know, acquiring equitable remedies on behalf of the investor, and if we say that disgorgement is an equitable remedy, which we are, then disgorgement is only for the benefit of the investors. To say that it's not for the benefit of the investors and you can put it in your general slush fund would not give value to the words and the writing of the text itself. So the Supreme Court, in a statutory analysis reading the text, says, if you're going to do disgorgement, it's for the benefit of the investors, right? So what does that
But that's
mean?
pretty broad. Maybe
that wasn't
it benefits
defined.
investors for them just to have people, you know, going around and charging future ICO companies.
No. The Supreme Court was very specific on that, saying that taking the money away from the defendant and putting it into, you know, a whistleblower fund is not for the benefit of the investors in general. That's not what the statute meant. The statute meant that the money taken from those investors, any money taken, needs to be linked to those investors. That was the dicta that was there. Right.
Right,
so anyway,
I want to move on to whether Bitcoin is money, but we do have some really good questions.
Read Lou. Lou is phenomenal. The textual analysis and everything else that's in there. It's a Scalia dream. 8-1 Scalia dream. It's outstanding.
So Will, which Supreme Court judge went the other way on this one?
Thomas. And what Thomas says is that we don't need to look at disgorgement from an equitable standpoint of whether or not disgorgement is allowed under equitable relief, because as Thomas points out, the idea of disgorgement, looking all the way back to courts of chancery, disgorgement was not included as an equitable remedy. So disgorgement should not be allowed at all because it wasn't included in original courts of equity. So that's why Thomas dissented, is he didn't think that that disgorgement should be allowed because it's not a traditional equitable remedy, if that makes sense.
It kind of makes sense, but if, let's say, 6 of them said the same thing,
Eight.
No. I'm just saying, like, if like 6 of the judges also thought the same thing, well, this shouldn't exist at all. So I'm not going to vote in favor of this, and then it's back to SEC collecting as much as they want.
No. At that point, what would happen if disgorgement wasn't allowed? Then the SEC is no longer allowed to collect ill-gotten gains.
Right.
But what does that mean? It means that the SEC still gets injunctive relief. They can still keep you from participating in anything. They can get a lifetime ban on being in the securities markets or participating in these things. And then what happens is penalties go up. Right now, penalties are relatively low in comparison to disgorgement, right? If we look at EOS, how much were they penalized versus how much they raised?
0.02%. Like
correct. So what you would see is a shift in the amounts requested by the SEC under the penalty provision if they were allowed to get that statutory provision to increase that, but that would require notice and comment and those types of things to adjust those schedules. But it would work itself out.
All right, we have a couple of really good questions, but I don't want to spend too much time talking about security law. I want to move over to the money transmission law. But here are the questions. Let's see if we can answer them really quickly. Have you ever heard of a case in which a retail investor was actually detected and prosecuted for, I guess, ICO bullshit? Not a broker or company or ICO.
You mean a purchaser?
Right. As far as I know, no. I have not heard of any trader that got popped for buying ICOs, selling ICOs. I haven't seen it, and I don't think that's going to be very unlikely. But let's.
I can't name a specific instance. However, what 10b-5 says is that any person participating materially, aiding and abetting is subject to the securities laws. So to the extent you had, let's say, somebody receiving securities as payment for participation, and they go out and are a mouthpiece and promote, now that investor or person who maybe got something and is promoting is subject to that. And I think we've had a few ICO instances where a primary investor was held on the hook. And one of those was, it wasn't by the SEC, but it was in the Tezos class action, right? Who was the guy that backed the Brightmans early on and then went out and was a
and also
promoter of that? It's popping in my mind, I'm sorry.
And David Silver is still going after Trayvon, James, and what was the other guy? Craig Grant. Yeah. So look, if you're a promoter of these scammy ICOs, then yeah, you're going to be.
That's where you cross the line, and that's the distinction. You can be an investor. Right.
But if you're quietly, buying into the shit and trading it in your basement without, blabbing about it all over Twitter, well, we haven't seen that, and I think that's unlikely.
Mm-hmm.
But that's not my non-professional opinion. Okay, he's got two more questions. I think they're all good. That's why we're asking him. Do you think the government will actually be able to ban stable coins, considering all the technical workarounds that make it easy to do business anywhere on Earth through VPNs? Stable coins are not a problem for the government because stable coins are, they're backed by something somewhere. So if the government really wanted to take down Tether, I mean, all they got to do is just shut it down. All stable coins are centralized entities. They're not decentralized.
Hold on. We have to make a distinction of stable coin, though, John. And what we saw in the last 2 years were people calling something a stable coin, but the stable coin itself was pegged to a volatile tradable token as opposed to some steady fixed asset, because the stable coin, alleged stable coin, is trying to be used to inflate the amount of trades that the sub token is being used for. We've seen a couple of those scams. So not all stable coins are alike. And I think just as we saw in early Bitcoin days, where you had a lot of scams that were damaging the name of Bitcoin, and so Bitcoin got this terrible name, stable coins are getting a somewhat suspect name based on the fast and loose treatment that some of these ICOs are using to try to prop up their own shit coins, right? So if we're talking about stablecoin as stablecoin, Tether back to the dollar, and they actually have the funds on reserve.
Debatable. We're going to find out.
And
Agreed.
We have, ever since Facebook came out last year with the stablecoin, we have seen a huge increase across the world of regulation from all different governments trying to regulate them differently. Right now, the U.S. has still said a few things indicating they might consider them as securities, but nothing definitive. And I think it would be a really difficult thing to actually pull off in court to prove that these things would be investment contracts, because the price is supposed to remain stable. But I don't think there's any desire for them to regulate it as securities. I think they're going to fall under the money transmission regulations mostly.
Well, if I can, I would be able to classify a stable coin as a potential investment or a derivative of a security, which then makes it a security in the scenario that I explained, where people are issuing stable coins in order to prop up their underlying asset.
Right.
Right. So that would be a scenario where if I were the SEC or a state regulator, if I was working for a state regulator again, I would jump in and say, no, because what you're doing is you're trying to manipulate markets, and you're trying to commit fraud on an underlying thing by getting people to use this to support up the other. And
I guess, on that side too, like, what is a money market fund? It's a security, but it's a fund of cash, or cash equivalents. So yeah, certainly there is ways to get things as securities, but I think the way that people primarily want to use stable coins, like the US government or the Chinese government, talking about making these stable dollars or digital dollars, that they're not going to want it in the securities category. And they have
it's just currency at that point.
Put these out. Yeah,
it's just money at that point. And I think just from a technological standpoint, stablecoins make sense from just in accounting purposes in exchanges, instead of having to go back to the dollar and actually having to have dollars on fund, you can have these digital assets on fund for clearinghouse purposes, for easy transmission, for
for the IRS. If we went to the digital dollar, it's very easy to see our, what taxes they can collect.
All right, guys, we have to jump on. We have to keep moving. So there's one more, and this one should be simple. Do you think the SEC will ever regulate exchanges to stop all the pump and dump schemes? Every single exchange will eventually be regulated with full KYC because they're all centralized entities. So eventually, there will be a handle on this. I mean, the U.S. regulators will probably have problems with some of the international stuff, but yeah. So the pump and dumps are not going anywhere. I mean, just look at penny stocks. They existed and they were pump and dumped before crypto came along. So the pump and dumps are independent of whether exchanges are regulated or not.
I mean, when we look at, sorry, go ahead, Sasha. Go ahead.
Beyond just the KYC requirements on exchanges, there's something else where, if you're selling securities, you have to be a national securities exchange, and the company has to do all these special filings to meet the standards to get listed on a securities exchange. So it is still very different if you're on a crypto exchange, and there's still the silly notion that everything on these exchanges are utility tokens, which we know they're not, and the SEC has just kind of turned a blind eye to it so far, except for
no, it's not that they're utility tokens, it's that they're not securities, because they're more money than
there's
anything
something
else,
other than securities is how they're looking at it, when easily, as you just said, you can probably classify a lot of the things that are on these as securities or not securities. There's an argument for both sides of it. So I think they'll need to come up with something like the pink sheets regulations, or something that's kind of a quasi. It's not going to meet the standard of a national security exchange, but there does need to be some kind of disclosure requirements to get listed that are, there's some overarching entity that's reviewing these and enforcing it, probably.
Lest we forget, in the last couple of years, we've seen an example of a cryptocurrency exchange trying to comply and be regulated and be monitored, and that's Gemini. Right. And then you had, the fund that the Winklevi wanted to bring along, and the SEC responded effectively saying, no, these are not mature markets. And so if you don't have a mature enough market to be able to say that the assets that are being traded are not subject to, manipulation through pump and dump stuff, to the extent that they're going to feel comfortable enough having an exchange fund listed that's based on trading that's happening on a market, that Gemini is saying, no, you can have complete look through to us and have access to all our records, and they still say no. This is a chicken or egg moment, right? The SEC has to say, sure, we'll go ahead and allow and start participating in these exchanges, and we're going to start trusting it when people want to be regulated, and we're going to start having trust in that. And I think the moment that we have kind of the seed moment, which is Gemini saying, we want to play, and the SEC saying, sure, you can play, but we're not going to let you play until everybody else plays. And you're like, well, come on, somebody give it. It's
all right, guys. So let's move on to news that broke out earlier this week. Whether, once again, it's a discussion of whether Bitcoin is deemed money. This one's specific to the District of Columbia. And here's...
All right, Tone, I thought I took care of that back in 2014.
Yeah. And
I thought I handled that.
Clearly. No, actually you didn't. You just missed it because of because of Charlie Shrem, actually, and right, because he got nailed and you couldn't get the appeal reversed, right?
No. It was our judge in the SEC v. Shavers case that said Bitcoin was money, and that was the shot heard around the world.
Well, right, but you tried to appeal it, and then it wasn't going to happen because the judgment was used for Shrem.
Correct. Well, from a securities analysis standpoint, I attacked the Shavers case on two fronts. I wanted the SEC to go back and have an actual definition of money that's defined by statute after notice and comment, because we had a federal definition of money, and I didn't want judicial rulemaking right? Adjudicatory rulemaking in order to determine what money was instead of the SEC running the courthouse. So that was the first thing. Said, no, let's have a real definition of what money is that actually includes cryptocurrency. So we can have a full discussion instead of some pro se guy versus an Illinois law school law review paper deciding if Bitcoin is money or not, right? But we have a lot of people that have something to say. So I wanted that. And then the second thing with that case was whether or not Bitcoin as Bitcoin itself was a security. So in the ultimate result in the Shavers case, where the judge said, no, Bitcoin is money. And while I was attempting to get the judge to believe that that should go back for notice and comment, then Judge Rakoff in the Southern District of New York came back and said, I'm going to rely on the Shavers judge to declare that Bitcoin was money, at which point in time, if you then reverse your decision as a brand new magistrate judge that's been ascended to the federal bench and you're going to deny Judge Rakoff, that doesn't work, just from a judicial politics standpoint. So yeah, it was locked in.
All right,
sorry,
so,
history lesson. History.
Right. No. That was on. Yeah, we gotta. It's been a while. Like, man, if we can get in touch with Shavers, would love to get him on the show one day, so we can like explain to people what all the ramifications from that case. But
actually, if you go into the Bitcoin Uncensored archives,
yeah,
Chris and Joseph, I was able to get Shavers on their show way back in the day. I think right after he got out of jail.
You know what else is in the Bitcoin Uncensored archives? The very first Bitcoin Law Review, with me hosting, you, Drew, and Adela.
In the bathroom. Yeah.
Bathrooms. Miami Bitcoin conference.
That's true. Yeah. That was a good show. We carried it into the bar of the hotel later on that night, and then it got really out of control.
Yeah, if you guys want to like a trip down memory lane, try to find the very first episode of Bitcoin Law Review. It's not on my YouTube channel, but it's there. I hosted it. It was literally taking place in the bathroom.
With people using the urinals behind.
Right, with people using the urinals behind us. Anyway, so this has to do with dot exchange Helix, which was using like coin joins mostly for the dark web websites. And in that case, so this is, I mean, this report is not that long, but it's thank God all the important stuff is right here. We can just read. So the motion to dismiss raises two novel questions. Is Bitcoin money for purposes of the District of Columbia MTA? Was Helix, which operated as a Bitcoin tumbler, an unlicensed money transmitting business under, I guess, Rule 18, Section 18 of one of the codes? This is your guys' territory. After examining the relevant statutes, case law, and other sources, the court concludes that Bitcoin is money under the Money Transmission Authority. Is it? What is MTA again?
Act, yeah.
Am I right?
Money Transmission Act.
Sorry, there it is. Under the Money Transmission Act, and that Helix, as described in the incident, was an unlicensed money transmitting business under applicable federal law. Accordingly, defendant's motion to dismiss counts 2 and 3 is denied.
Okay, so Tone, before you move forward, explain to your audience what a tumbler did, because we don't use tumblers today as much as we did back in the day.
Right, which is kind of
this isn't a normal tumbler either.
Right, so a tumbler basically mixes your coins with other coins to conceal,
obfuscate.
To obfuscate where they came from. Now, here's the interesting part. Again, I'm not a lawyer, so not legal advice, but the act of tumbling your coins, as far as I know, is not actually illegal or criminal. You are more than welcome to tumble your own coins.
That's not true. This is
Where,
not true.
okay, you're going to correct me here. Where the
Yeah.
problem comes in is if you are advertising this. So it's almost like Jason's going to correct me here, and I might argue with him on this one. So, for example, if I'm holding a bunch of $100 bills and I kind of want to mix them up, that should, as far as I know, that should not be criminal, nor is that criminal. But if I know that I'm doing it to because though they came from somewhere shady, or because I'm gonna put them somewhere shady, that could be a little bit of a mix. But it's almost like, for example, if someone owns like a password cracking device, like, hey, I just built this algorithm and it can crack Jason's password. Now, if I start advertising it that way, I'm in trouble. But if I advertise it as, hey, I wrote this cool program. If you forget your password, this will really help you recover your own files. That part is not criminal. But if I start advertising it as breaking into somebody else's computer, then I have a problem. But Jason, go ahead and correct me on tumblers. And
no, your distinction was well made after I raised my objection. If you're using a tumbler in order to obfuscate the source and destination of funds, or the source and destination for the purposes of obfuscation to bypass regulation or some viable statute, you're falling under what can be called money laundering, right? Now, a tumbler itself, generally way back in the day, before we started having privacy coins, you used a tumbler to send Bitcoin from your wallet, because we didn't have wallets that automatically created new wallet IDs every time we tried to use them, et cetera. We just had an wallet, and we would send that to a tumbler, and that tumbler would then take other clean coins and start creating a bunch of multiple transactions and reforming and recreating and breaking down and recompiling units of coins and then shipping them out to a destination of your choice or multiple choices in order to try to break the ability of a normal human being or software at the time's ability to track the source and destination of those two transactions, which means necessarily, from a money transmission definition, where Sasha can come in here, is that for a period of time, my coin being sent to somebody else, which is not money transmission, spends time under the custody of somebody else's control prior to transmission, and that person controls where it goes to. So you have a source of funds, a destination of funds, custody and control of something for a period of time. The person that's acting as custody and security of funds being transmitted is a, Sasha? You're muted. We can't hear you.
No, still can't hear you. Could be an audio issue, but the answer.
Well, the big reveal was a money transmitter.
Money transmitter, yes. I can answer that as well. Sorry, Sasha, we don't have your audio. But yeah, that's a money transmitter. But that's because back in the day, Jason, all of these tumblers were basically centralized programs controlled by an entity.
Or a person.
Or a person, right? Entity or a person. Today, they're more smart contracts, and they will be embedded in wallets so that there is no single concentrated person. Though this will come in further, sooner or later, there will be a court case that decides whether a wallet that has embedded coin join, whether the creators of that wallet are money transmitters.
Well, and also, so in this one, the defendant, or through Helix, he was taking custody of the coins and then sending them different coins back. So it's really clearly transmission, whereas some tumblers don't take custody of it, and that isn't going to be money transmission unless the law is, rewritten around it. So there's that issue, but clearly, as Jason, very nicely outlined, in this case, there's money transmission. But I remember reading this case when it first came out, thinking, how are they going to get them on the DC money transmission license? Because for as long as I can remember, I've been writing people, opinions saying that DC, it's not a state where, like, for instance, you can operate an ATM here in DC without a license. And
now I think that's all going to change. So it's going to be one of the states, you know, like New York or Alaska or Hawaii, where it's a real challenge to do business, even if you're not dealing with fiat currency.
Are you talking about BTMs?
Yeah, or any kind of non-fiat dealing exchange or in DC before, you know, basically all the states all have these money transmitter, you know, statutes. And the way that we've typically looked at them in Bitcoin is if they don't specifically articulate that they govern Bitcoin, they're not a state where someone needs to get a specific license. But now, so in Florida, that was the case, and they rewrote their statute so that they, you know, they changed the words so in their money laundering to specifically include Bitcoin, but they didn't change the words in their money transmitter statute to include Bitcoin. So one can, you know, make the assumption that if they wanted to include Bitcoin as a money transmission, you know, regulated activity, they would have also changed the statute. But then they had the case against, oh, what's his name? The guy that, anyway, he sold Bitcoin using local Bitcoin to an agent, and he was charged with transmission. And then they said, the court said that is money transmission. That, you know, Bitcoin is defined as money in Florida. But then the Florida Office of Financial Regulation will still issue a no action letter stating that you don't need a license. So it's like two, you know, the court and then the regulator are at odds. So I don't know here, you know, we just got this. Does that mean someone operating an ATM in DC can get charged with, you know, potentially 5 years in jail and a felony and 25 grand? Or is there going to be a grandfathered in, you know, time frame for the people that are operating who are already registered with FinCEN but not registered with the you know, district?
Well, isn't there a distinction, Sasha, between money transmission and exchange in a lot of these jurisdictions? So a Bitcoin or a BTM, right, for the most part is used for exchange, right? Fiat to Bitcoin, Bitcoin to fiat, or some other currency. It's very rare
transmission happening in that
right. And in the BTMs, mainly when people are using them, it's very, I would say the percentage is low, the amount of actual transmission that's being used from party A to party B. And I think in some of the machines that are out there, you can pay for services like the, Doug Scribner's machine.
CoinLogic.
Thank you. The CoinLogic machine allows you to buy concert tickets, et cetera, et cetera. Nobody would argue that putting Bitcoin into that machine or paying for a concert ticket is money transmission, because that's just consumption, right? You're not transferring from one party to the other. So in DC, it is a BTM where it's just exchanging fiat currency for Bitcoin. Is that transmission or is that exchange? And what does it matter under those statutes?
Mm-hmm. In a lot of them, it wouldn't be transmission. So it is distinct from the activity happening here, where Harman was taking money from Alpha Bay, transmitting it to Helix. Like he physically did that transmission, or his company, you know, so it moved it to a third party, Helix. And then from Helix, there was another transmission again to, you know, the end user who wanted the clean Bitcoin. So it is quite different, but I think now this does make DC a, you know, one of the jurisdictions that's you know, needs to be revisited for everyone that's already operating there without a license.
Yeah. Well, you know, this is one of those moments where you know, anybody really in that jurisdiction may be able to call up, you know, you know, a representative or somebody that's in that panel and ask for some form of notice and comment in order to have a more clear definition of how that works and actually go into a rulemaking process under administrative law procedures. And you know, if DC has you know, a request period or ability to submit requests for for modifications to rules other than that being raised within the regulatory agencies themselves, that would be an opportunity to look at when that window is for requests for considerations on things.
Mm-hmm. Yeah, that's good. Good plan.
Yeah, so before we move on, you mentioned the Florida money transmission laws, and how much did the Mitchell Espinoza case down in Florida have to do with that? You guys remember that one?
Yeah, that's what I was referring to. So this, I think, puts the District of Columbia into a very similar situation as Florida, where they have a court hearing, but then it's a different. So in talking with the Florida regulators, they weren't even consulted in deciding that case for Espinoza, and they had already issued several no action letters to people operating in Florida saying that they didn't need a license, and then the court came out saying you do need a license. So it's a mess, but they're still allowing people. They're either not responding to no action letters, which essentially allows the person after a certain amount of time to operate, without too much fear, or they're telling you verbally that you can go ahead and operate a certain, depending on the situation. If you're dealing with cash, it's if you're doing the third party transmission, it's different than if you're doing Bitcoin ATM operations.
Yeah, and help me out here, because I haven't followed the Espinoza case like you have. Is the court here saying that any person, a private person, just selling their Bitcoin is a money transmitter, or is it a person whose business it is to is engaging of the business as a normal course of business, is the center of their activities, selling Bitcoin, a money transmitter?
I'm pretty sure it's business, but I'll let Sasha answer it.
Well, it's always supposed to be a business, but they effectively, the guy Espinoza in, I think it was 2015, sold a very, very small quantity of Bitcoin to an officer that, he wasn't holding himself out as a business. He was operating, but they said he was, because he was operating on the local Bitcoin website, but he was just an individual thinking he was meeting up with another individual. And the appeals court, the Judge Polar, said, I'm not going to rule that someone can't sell their personal property to another person,
right,
especially under statute so poorly defined that all these legal professionals are arguing over it. And then that's what prompted them to change their money laundering rule, but not the transmission, the wording of it. They didn't add Bitcoin or cryptocurrency to it, where a lot of states have updated their wording to include that. So.
And Espinoza is one of the few that actually won. I mean, he at least he won on appeal.
He won, but then they brought it back last year without consulting the Florida Office of Financial Regulation. It was really bizarre that they brought it back out, and then they didn't. When ruling on it, they essentially said that it is against the money transmission rule to sell anything to anyone. They didn't have the third party transmission aspect included in their definition of it. So
wait, I'm sorry, I didn't know that this thing came back out. I thought that so are you allowed to sell Bitcoin to a friend or not? Like, what the hell's going on over there?
Depends what state you're in, but in Florida, according to the way that they had, according to Espinoza right now, no, but according to the Office of Financial Regulation, yes. So that's why it's really quite a mess in Florida at the moment.
Well, it sounds like it's ripe for some impact litigation. And really what that would mean is that an interested party would file a complaint for declaratory ruling based on that specific activity of one private party selling to another, declaratory judgment. And so really impact litigation seeking declaratory judgment is a very expensive process, but it's a way to do adjudicative rulemaking and limit the policies and enforcements later. So, for those people that are watching out there and have friends in Florida and want to pass the hat around to set up, an impact litigation lawsuit in order to get a determination on this from a judge, now's the time to do it because the issue's right. Having the correct person or the person that would have standing to do that would be somebody that's just has a reason to sell or has tried to sell or may sell in the future Bitcoin to a private party. And so long as the IRS declares Bitcoin to be property, then there's at least some notion of standing to be able to do that and get some sort of determination there. So that was my pitch for you to get business, Sasha, from the peeps that are watching to go past the hat campaign.
I'm surprised David Silver does not try to take up the mantle on this one.
Well, I
not as bad.
filed a lot of these petitions for declaratory statements with Florida, probably, I don't know, 5 or 6 at least in the last 12 months, and they won't issue. They'll issue it in certain cases when there's no Bitcoin involved. They'll issue it, but when there's Bitcoin involved, because it's such a strange situation with that court hearing in the Espinoza case, they're just not.
Are you talking about from the administrator's office?
Yeah.
Yeah, I'm talking about filing in state or federal court.
Oh, okay, yeah, I haven't done that.
Getting an actual judge to make a ruling on that for the judge to interpret their rules. Now, of course, Chevron comes in, blah, 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 blah. But, you know, for the lawyers that are watching, nobody wants to get into a Chevron argument. It just, you lose sleep for months.
I have so many questions on this because I had no idea. I thought this Espinoza decision was done with, wow, I need to read this article. I need to add it to the description. So I just have a couple of questions. I don't even know if we want to we can go down this rabbit hole for a while. I was always under the impression that you as a private citizen don't really have an issue. I mean, if you are buying Bitcoin from one person and selling Bitcoin to another person, if you're a local Bitcoins dealer, then you are in trouble with the money transmission laws. But if you are just, selling your Bitcoin to another
Hold on. A resident of Florida sells their Bitcoin to Coinbase. That resident is now a money transmitter? That's stupid.
But that's kind of what the court case said, which is it's ridiculous. And I don't think it's like what Jason said. If you do one of these, cases to prove how silly it is, there's all kinds of holes in it. But what you're saying, Tone, on the federal level, you're fine because you're a user. It's only if you're an exchanger or an administrator that you have to file anything federally. So if you're just a user, exchanging with a friend and you're not holding yourself out as a business, if you're not making a big profit off of it, and primarily if you're not in the know that this money is obtained from selling illegal credit cards and you're dealing with an undercover agent, you're not going to run into any problems.
Right. That I mean, unless you're in Florida, apparently. But maybe, we're not sure. But see, again, I was always under the impression that you can buy as much as you like and sell as much as you like, as long as you are not profiting from that transaction. So as long as I am buying from you without, basically taking a cut. If I'm buying from you and I'm buying from you below market price, I'm profiting from that transaction. If I
hold on. I mean, come on, Tone. I mean, listen, from a pure market capitalist standpoint, if somebody is coming to me and asking me to separate my precious fiat dollars in exchange for their lowly Bitcoin, and I get a fig on that, don't sue me for being an opportunist. It doesn't mean I'm in the business of doing it. It means I'm a smart goddamn capitalist.
I'm with you. No, Jason, I'm with you. But I've always been under the impression that if you are basically buying, you can buy Bitcoin at market price, but then you are reselling those Bitcoin for a profit, you are probably a money services business. And
no. But listen, even right there in what you said goes down a slippery slope, because if I buy Bitcoin today, and what's it at right now? Is it still above 11? And what's the countdown clock for you buying a steak dinner? I'm just curious, asking for a friend.
I'm down 9 days.
Okay, so what's Bitcoin at right now?
1100.
All right, so 11,000 you mean?
11,000, yeah.
Okay, so I buy Bitcoin today at 11,000.
Sorry, guys.
Let's say tomorrow it's at 13,000. Remember when it had that huge run up a few years ago on its way to 20?
Oh, of course.
And it went from like 10 up to 14. It was just ridiculous. So let's say tomorrow's at 14. I sell tomorrow at 14. I just sold Bitcoin at a profit.
No, but that's different. No, but that's different. Right?
That's what I'm saying. It comes down to the interpretation of how it's interpreted. If you say you purchase at one price, sell at another, and you earn a profit, now you're in the business of being a money transmitter. So you have to get into these granular analyses of base price for selling price on those days. What's the intent of the transaction? Now, all of a sudden, we've got this bright line 15-part test that we have to go through in the court of deciding, was the sky blue that day? Was there a thunderstorm? And all of a sudden, you're a money transmitter.
But there are, I mean, like most of them are, there's a bunch of people sitting in jail already for basically being local Bitcoin dealers. Now, most of them are in California.
Because they were actually money transmitters trying to make them
out. Well, I think the idea is that they were holding themselves out as in the business of, like, that was their main source of income. You could search them on the internet and find them. It's not like doing some deal with your friend over dinner.
So as far as that Florida, let's say, Florida is a big question state on this. Does it have to be is it within the borders of Florida? Like if two Florida residents, hop the border over to like Savannah, Georgia or something through Florida law doesn't apply, right?
Hold on, now you're talking about the illegal transportation of Bitcoin across state lines, which now you're moon coining, right? You're not moonshining, you're moon.
Well, no, but technically, wait a minute, Jason. Well, technically the Bitcoin, Bitcoin is on the blockchain. Bitcoin does not reside in any state. So
thank you for picking up on that. I love it.
Well, they tried in this Harman case, they tried to use the UCC definition for money to define Bitcoin, which is where the court actually relied on Shavers, Jason. But they were trying to say that it's not money because money has to be, backed by the government, etc. And then that's why this case was 49 pages long, because they went all through the various definitions of money. But then, the court said, no, we're going to say that Bitcoin's money here because it's, a store of value. It's a means of exchange, et cetera.
Okay, so sticking with that topic, I want to move on. And we've just spent like 40 minutes talking about whether Bitcoin is money or not. And I know, Jason, you did your best to try to claim that Bitcoin isn't money.
Under the federal definition.
Right. The governments all over, the federal government and the state governments, all want Bitcoin to be money. So if Bitcoin is money, why are we paying taxes on Bitcoin? We don't pay taxes when the US dollar rises in value, right? So this is a separate case for the IRS, but this is another story where the IRS just tries to collect the data, and someone is suing the IRS for basically demanding all of the personal information of the Coinbase's users and other companies' users. So we have Mr. R. Harper here decided to sue the IRS for data collection and violation of, I guess, the Fourth Amendment, maybe, or one of them.
Yeah, the 4th and 5th.
Which one?
I think they cited the 4th and 5th Amendments.
4th and 5th, right. So he's trying to say, hey, wait a minute, the IRS doesn't have the right to just request all personal information from an exchange for their collection. But there is a higher level question here. If Bitcoin is being classified as money, how does the IRS get to classify it as property, taxing us on a coffee payment if the time between us buying the Bitcoin and us buying the coffee has gone up? So when you spend Bitcoin on that coffee cup, you better calculate your capital gains increases on the value of a Bitcoin. If Bitcoin is money, how does that make any logical sense? Can you guys try to tackle these two issues?
Well, I think Coin Center tried to make that argument twice now with, they tried to get the de minimis exemption on it so that it would Bitcoin would at least be treated similarly to foreign exchanges, where if it's under $600 of a gain, it's not counted. But
600, I thought it used to be 200, I think. So, or I thought it was 200. So that's great. Okay, so let me just explain to the people what that means. That means that if you happen to leave Europe with a bunch of euros in your pocket and you forgot to exchange it at their 45% exchange rate at the airport. If anyone's ever tried to convert your euros into dollars at an airport, Jason's laughing because I'm sure he's ran into that problem. I've actually seen a 50% exchange rate between the pound and the euro at the airport. So if you happen to come back from Europe with 500 euros in your pocket, and then a year later, those euros went up in value by, let's say, 10%, you do not owe any money to the IRS because of the exemption Sasha just talked about.
Mm-hmm. But it has been shot down every time that they've, put it forward for Bitcoin under, the same way that they make the argument that it's money. In this case, they can make an argument, no, money is only money if it's backed by the full faith and government, and whatever of the government. So it's just a double standard because, they're the ones with the power.
All right, so Jason, what do you think about this? If Bitcoin is money, why are we paying taxes on the value appreciation of Bitcoin?
Okay, first of all, when we started talking about bringing currency over from one place to another, I wanted.
Done. I got a 6 o'clock call.
We got to let go of Sasha.
Yeah.
Can you come back after the call? We'll still be on.
Maybe, but I got to do dinner.
Okay. So
I'll talk to you all later.
All right.
What's that, a Zimbabwe dollar?
No. Read it.
A peso. Okay.
No.
A peso of what? Let me drop the screen share. Banco de Central which peso is this? It's like, Cuba. You got Cuban money.
Okay, so I was supposed to trade these in at the airport before I left Cuba the last time, before they shut down travel restrictions. Okay, I was there as an international athlete for sailing. I think some of your viewers know that I race sailboats. I forgot that this was in my pocket. Okay, so right from the get-go, Cuba charges a 20% premium to not only acquire these, but also to sell them. So at the end of the day, when you trade your dollars in or out, you're losing 40%. So this, in and of itself, has a 40% value against the dollar through that transaction. How am I supposed to register this as an asset? That's my question after these stupid laws.
Yeah, that's kind of insane. So you have to
This is money.
You have to pay Cuba 20% in each currency conversion?
Yeah. And by the way, Cuba calls these kooks. Cuban units of currency. They're kooks.
So Cuba ain't exactly, so what happens if you use your credit card? Do they charge you 20% as well?
No. So the smarter move is that if you know where to go in Cuba, you can actually pay in dollars, because you can find side games where they'll do 10%, 5% conversion.
Oh yeah, of course.
Right, so you can find the side game, but having some kooks on hand when you're traveling around is not a bad thing. So the issue that we're talking about when we're talking about taxation versus property versus money versus values go up, values go down. Really, what we're looking at, if I'm to put on my regulator hat, is I would say you need to look at once again, it comes down to use, right? When you have your Forex traders and they're trading in foreign currency on a daily basis as a means to make money or not make money, right? If you're a bad Forex trader, you're in the business to not make money, you're just throwing it away.
I agree.
If you're in the business of being a trader and that's your occupation, absolutely, capital gains should apply, investment income should apply, all those things should apply. But if you're just a normal everyday jackass that holds Bitcoin and you're using it to buy a cup of coffee at this point or the other, and you are a private citizen engaged in a private transaction with somebody else, and they are willing to give you a price for your Bitcoin at that point in time, and the transaction stays wholly in Bitcoin as a percentage of Bitcoin based on that value, then you were two parties that have engaged in a transaction in free capitalism, and you're trading your property back and forth, and that is what's called money. It's not property at that point, it's money. Because money is exchanged for goods and services.
Right. And I wish
Right?
that's how the law was, but here's a slight gray area for you, though you may not see it as a gray area. I
probably do.
If you are a currency trader trying to profit, yeah, your profit is, I mean, I may not agree with that this should be taxed, but I think that the law is there. And yeah, if your job as a trader, profiting from currency trades and shitcoin trades, whatever, then yeah, those profits should be taxed. But what if you are an employee being paid in Bitcoin and you're saving that Bitcoin in order to delay purchases? So you're not immediately selling the Bitcoin. You're not immediately spending the Bitcoin. You're being paid in Bitcoin like you're paid in dollars. You're storing that Bitcoin. It does go up in value because that's what Bitcoin does. And now you're able to buy more goods and services. You are not a currency trader. You could
speculator. You're a speculator at that point.
Maybe, but hey, what if I choose to be paid in euros? Am I a euro speculator now? What if I work for a European company? I happen to be an American, but I get paid in euros. Am I? What happens then?
See, what at any point in time when any government agency is trying to regulate some form of behavior, they're going to look at the behavior and determine if the things that you're doing are good faith or bad faith. Are you trying to get around something? What is it that you're doing that is the problem, right? If there is a problem. So Overstock.com, right? They paid a lot of their employees in Bitcoin. Okay, and if my agreement was to get part payment in fiat and part payment in Bitcoin, and I spent my fiat on my normal days, and I saved my Bitcoin for 5 years because my intent is, I know in 5 years I'm going to 2000x, and this is an investment strategy for me. That is the same tone as receiving payroll in dollars in part and stock in part in another. It's a speculative venture because you don't know if it's going to go up or down. You're taking that risk when you agree to get paid in something that's as volatile as cryptocurrency. Now, if cryptocurrency was not volatile, if it didn't have that speculative component, this wouldn't be a question. But because the very nature of the markets themselves being unsettled and unclear, we have that speculative component.
Well, volatility is subjective.
No. What I'm saying is that you would have to ask that person that held it for that length of time, why were you holding it? Was it for the speculative purpose, or are you just a saver?
Well,
right? Did you set aside half of your paycheck in a savings account every time? Mimicking the same behavior.
Well, Jason, based on our earlier discussion on this very show, I like my assets to be unconfiscatable. Like so that I'm not, the next situation where my bank account gets frozen, right? So, for example, I have plenty of evidence on videos that one of the reasons for holding crypto is that, in case you have to buy a lawyer, you have to buy a lawyer. In case you have to hire a lawyer.
I'm not for sale, but you can rent me for a while.
In case you have to hire a lawyer, you're not going to be in the situation, which I'm not sure how the hell Trayvon Shavers ended up in that situation, if he had no money to pay for a lawyer, but I guess he returned everybody's money and he had no Bitcoin left.
Well, no, the SEC froze all of his assets.
Right. But they wouldn't be able to do that if he had enough of it in Bitcoin. So there's
No, you don't understand. When assets are frozen, the SEC goes forward and says, these are all of the wallet addresses. And at that point, any funds that may or may not have traversed from those wallet addresses that are presumed to be under his control, he's then held in contempt and instantly potentially sent to jail and or held as a liar. So when you have an asset freeze, know that the SEC already knows what all of your wallet addresses are, and they're monitoring all of those. And any attempt to move those at that point in time is indicia that you're violating that order. So there's ramifications.
Be careful how you store your Bitcoin. But look, an argument can be made that I have absolutely no idea. I'm not storing Bitcoin because the price is going to go up. I actually believe there are people that, let me not offend anybody, but there are people that believe in all kinds of crazy things, right? And they have freedom of religion to do so. So therefore, my religion is Bitcoin. And I believe that Bitcoin is a very
Welcome to the Church of Lord, brother. Church of Lord.
And I believe that Bitcoin will be at current price, whatever the price is, $11,200, whatever the current price is. I have no idea. I haven't looked at it all day, except my show in the morning. So whatever the price is right now, I believe that Bitcoin will stay stable at that price. But I don't trust the banking system. And that is why my money is in Bitcoin. It's not being held in Bitcoin for speculation. It's held in Bitcoin because I trusted more.
Okay.
So again, it's kind of subjective whether you're holding Bitcoin because you know for a fact it's going to go up. It can go down. It has gone down. We're still down 60 freaking, not anymore. We're still down 55% from 3 years ago, for God's sakes.
I don't disagree.
All right. Anyway, so what do you think this guy's chances are on suing the IRS for blanketly requesting all personal data from third parties?
I think at the initial level, he's going to lose. And then it's going to be a question of whether or not he's got any type of funding for appeal and to take it up. So this is a 4 or 5 year process to get a positive result. Whoa. If there's going to be a positive result. Because if the IRS loses, they're going to appeal, right? So after all the appeal processes go forward, if there's funding to do it, you're looking at a 4 to 5 year process to get the answer.
Well, honestly, I think this would be interesting to go all the way to the Supreme Court if they continue to challenge or claim that the IRS is violating the 4th and the 5th Amendments.
4 to 5 year process.
All right. Well, we'll keep an eye on that. Hopefully, we're still doing the show.
I hope so too. We'll put a pin in it and a reminder for 4 years from now to revisit it.
No. See, this is why there are still some people watching the show, not as many as when we started. But hey, guys, so I think this case is really, really important because
no. Listen. The viewership dropped to the same level that it is now at the exact moment that Sasha left the show.
I know.
That's what that is. It's not content matter, it's viewership matter and what subject matter they get to participate with.
I know. We don't have the sex appeal anymore, Jason.
Prove me wrong, right? Two balding white guys with facial hair talking about, whatever.
All right, guys. Oh, no, but seriously. So this is actually, I think this is a really important case. Anytime someone is challenging government authority, claiming that it's a violation of the Constitution, I find it interesting. It's coming out of New Hampshire, which is, tries to fight for freedom for us. I was just there the other day. Actually, it feels like it's like a month and a half ago now for their Freedom Festival. And can you guys, if anyone hears any updates on this case, I'm very curious because if someone can successfully get the IRS to hold back some of their power, that's a good thing for all the citizens. All right. So, Jason, we have a couple of directions we can go to. We can go talk about the latest in Tether. We can talk about the latest in Ripple. We could also, those were our topics, but since it's just you and I, maybe we'll save that. We'll have to do another show soon because Restus was going to make it and didn't, and Gordon was going to make it and didn't, and Adela got busy. So maybe we'll do the show again soon and cover those. Have you seen HR 6154 bill currently up for public comment? Because maybe you and I can just go through it real quick. It's a pretty short bill.
Oh, this is the Cryptocurrency Act.
Yeah.
Sorry, I don't know it as HR 6154. Sorry.
All right.
Okay, go ahead. Lead the way.
All right. So because I just did a podcast with Marshall Hayner, who was responsible for writing this bill, along with some people and I guess lobbyists. And so I went through it with him because while I know Marshall from back in the day, back before the whole shitcoin craze, and I like him, I get along with him, but he's a little more, open-minded when it comes to shitcoins than I am. And there are a couple of things in this bill that I'm not like all that thrilled with. So let's just go through the definitions because I have a problem with some of the definitions. So he defines basically 3 types of assets within the cryptocurrency space. He suggests there should be something called a crypto commodity. The term crypto commodity means economic goods or services, including derivatives that A, have full or substantial fungibility. The market treats with no regard as to who produced the goods or services, and C, rest on a blockchain or decentralized cryptographic ledger. So
what does that mean? What is that? What does rest on a blockchain?
Okay, so
decentralized cryptographic ledger mean? What does that mean?
Let me try to explain the logic.
What does rest mean?
I know. Let me try to explain the logic. So, or maybe we should read all 3. So basically, he breaks down cryptocurrency into 3 types. So crypto commodity is basically what Bitcoin
is. Oranges. No, because Bitcoin is not oranges. Bitcoin is not fungible, right? But he's saying that there's this commodity is fungible.
I can make the argument that Bitcoin is fungible.
No, it's not.
Yes, it is.
No, it's not.
Yes, it is. Okay, well, we can debate now. Look, Bitcoin is fungible enough. Well, it may not be fungible enough yet, but it will be fungible. Bitcoin will be fungible once the latest privacy tools get in the code, and they're coming. So, but the concept of a crypto commodity is something.
So I accept your apology.
Fine. But nobody uses Monero, so it doesn't matter. But Monero would also fall into the crypto commodity bucket. So basically,
I don't think so. Not at all. Monero is a cryptocurrency, period.
Okay, so here's the definition of a cryptocurrency. The term cryptocurrency means representations of United States currency or synthetic derivatives resting on a blockchain or decentralized cryptographic ledger, including such representations or synthetic derivatives that are backed digital assets that are fully collateralized in a corresponding banking account, such as stable coins, or synthetic derivatives that are determined by decentralized oracles or smart contracts and collateralized by crypto commodities, other cryptocurrencies, or crypto securities. So basically, his definition in this bill of a cryptocurrency is things like Tether and things like MakerDAI, because MakerDAI isn't actually backed by US dollars or euros, or it's basically a synthetic derivative derived through smart contracts. So he's defining in this bill cryptocurrencies as mostly stable coins, and things like Monero, things like Litecoin, even things like Ethereum as crypto, and obviously Bitcoin as crypto commodities.
So full disclosure, back in the Shavers case, I argued that Bitcoin should be more treated as a commodity and regulated under the Cftc than it should under the SEC, or transactions under the SEC. And so this kind of is bringing up old memories of old arguments based on the understanding of how the market developed and what things were being used for, how it was being used at the time. At the time, Bitcoin was used more as a commodity than as a currency, right? And so if we want to define Bitcoin as a store of value and not a unit of exchange, which I believe a lot of people like to do today, which is different than back in those days, then sure, Bitcoin can be a crypto commodity. You know, because not a lot of people use Bitcoin as a payment system, right?
Right. So
that there is a speculative component to that. So going back to our IRS question, we already know the answer of how to treat that, and then every single state that's ruled that Bitcoin is money it needs to shift, because now we're just, you know, we're paying in commodities, and now we're back to the old barter system. And when I pay somebody, or you pay me, or David pays me, or I pay you, and or I pay David in Bitcoin, I may as well just be handing you a bushel of apples, right? An old barter system. And now we're starting to make those arguments that it's free trade across the board. To call a cryptocurrency only something like a stable coin is basically hearkening back and asking for originalist definitions of what money is, which is what I tried to do in the Shavers case, have a true definition of that. So I understand where this is coming from, but this is 6 years too late, right? So you have to unwind state and federal regulatory law and state and federal judicial precedent to get this passed. And so I give it like a 1% chance of success if we're already doing a predictive market, right? If you and I represent Augur, if we're going to do our own little Augur chain here, I give it a 1%.
Well, the Augur token would probably fall in the crypto security bucket, which we're going to get into. But can we just get back to one more time to this concept, is Bitcoin fungible? So let me just throw like a quick argument out there. So Bitcoin is, to me, Bitcoin is fungible. It's not private, but it is fungible. Like one Bitcoin is as good as any other Bitcoin. It's not like a chicken, right? Like one chicken is not as good as another chicken. So chickens aren't exactly fungible, right? But for example, to me, Bitcoin is as fungible.
But are eggs fungible?
Let me finish.
Are eggs fungible?
Not necessarily. There's only one place where I buy my eggs. So to me, eggs are not fungible. Eggs from the same chicken are fungible. Eggs from the same farm might be fungible, but eggs that I buy at the farmer's market are certainly not fungible with eggs from Walmart. So no, eggs in general are not fungible to me.
All right. Okay. But so now when we talk about Bitcoin, are tainted coins better or worse than clean coins? Getting back to our mixing days. And now I ask, is Bitcoin fungible?
Well, here's the thing, right? If I know the coins are tainted before I accept them, I'm not going to accept them not because the coins are tainted. I'm not going to accept them because of the person giving me those coins can get me in legal trouble. I don't have a problem with the Bitcoin.
But if you're smart, you're going to pay less money for the tainted coins than a clean coin.
Well, maybe not, right? But my view is, but if someone is handing you a bunch of physical dollar bills, if someone is saying, hey, Jason, I have a suitcase of 200,000 worth of US $100 bills. Can you give me 18,000 and $20 bills for it? These are legit government bills that are not counterfeit. You know, like how is it different than Bitcoin?
And I'm aiding and abetting in money laundering.
Well, right, but the dollar bills are fungible, right? So to me, Bitcoin is as fungible as
unless they're marked, unless there's a die pack in there, right? So it all
exactly. So you can track serial numbers on paper dollar bills the way you can track Bitcoin transactions through the blockchain. That doesn't mean the US dollar is not fungible. It just means that it's not as private as we'd like it to be. But it's certainly fungible. That $100 bill will buy you the same amount of stuff. But if someone hands me an egg from Walmart, I'll know it's not the egg from my local farmer market. I can tell the difference.
All right, moving on.
Okay. Anyway, so finally, he defines, so there's three types of crypto things. Crypto commodity we covered, cryptocurrency we covered, which is mostly stable coins and other derivatives of crypto commodities. And now we have crypto securities. So crypto securities, in general, the term crypto security means all debt and equity that rest on a blockchain or decentralized cryptographic ledger. So this sounds like anything on top of Ethereum is automatically a crypto security.
That's not correct.
Well, again, that's what it reads to me. We can talk about whether it's correct or not.
You're talking about debt and equity, right? Debt and equity is very specific.
Okay, so you're right. Maybe that doesn't mean that. So let's move on. Let me just read all of it and then we'll discuss. Let me just finish reading it. So in general, the term crypto security means all debt and equity that rest on blockchain or decentralized cryptographic ledger. Exceptions. The term crypto security does not include the synthetic derivatives that is operated as and is registered with the Department of Treasury as money services business, as defined under section whatever, and is operated in compliance with all applicable requirements of subchapter 2 of chapter 53 of title 31 of the U.S. States Code, commonly referred to as the Bank Secrecy Act, and all other federal anti-money laundering, anti-terrorism, and screening requirements of the Office of the Foreign Asset Control of Financial Crimes Enforcement Network. So this seems to be unreasonably broad, and I bet you—
No, that's incredibly narrow.
Well, no, this—
designed to be incredible.
No. The exception is incredibly narrow. The in general part is incredibly broad because I think he's misusing the terms debt and equity. And
so let's go back to one of the first solo shows or duo shows that you and I did, and that's the Ethereum as a
Ethereum
scam.
case, yeah.
Right? When the Ethereum ICO pre-sale happened, was that debt or equity?
It was the Ethereum ICO that took
pre-sale.
Well, again, it's debatable. To me, it felt like equity.
But it's not. There's no interest in the organization. That's equity. There's no guaranteed interest in the organization in order to give you voting rights, in order to give you a share of the company, in order to give you anything.
Right, we agree on that. You know, removing the rights of the user to get around the security law is kind of—
I'm not saying it did. Remember, what's a securities analysis?
Like I said, I agree. He's using— you are looking at these terms, debt and equity, very literally from a legal definition. And it feels like they're just thrown in here randomly, implying that any ICO falls into this category. But obviously,
this is very well designed. This is very well designed and very poorly designed to not accomplish or to specifically accomplish what he wants. And I don't know what this guy wants, right? But an investment contract is not debt or equity, but an investment contract is security, is a security. We do the Howey test all the time, right?
Right.
And you do not need debt or equity for something to be a security.
Right.
Okay. Tell me where the Ethereum ICO pre-sale falls into these categories.
Well, it doesn't. It doesn't fit.
Go back up to your crypto commodity. Let's read that again.
Right. It doesn't fit this. There was no blockchain when they sold the ICO.
Correct.
So it can't fit crypto commodity. It wasn't fungible. It didn't even exist.
Correct.
They sold it. So clearly it doesn't fit all of these. The market treats with no regard as to who produced the goods or services. You know who produced the ICO? It was Vitalik and team.
Correct.
So it doesn't fit it doesn't fit. Right. It doesn't fit crypto commodity. It certainly doesn't fit.
It's not a stable coin, and it's not a security. Do you see the gaping hole of shit coins that come out of this?
Well, I believe it was a security, but it's not an equity and it's not debt. But I believe it's of.
But there's a specific exclusion when you read statutory language and statutory construction from a legal construct. Statutes are designed to be read, and you cannot add or exclude language in a statute. That's improper. Okay, so the term crypto security means all debt and equity that rest on a blockchain or decentralized cryptographic ledger. Meaning, you want to call something a security that's a crypto security, it only means that it's this, right? So this is specifically designed to try to create some legal chicanery, is how I read this. And then you have the shitcoin world all over again. And I don't think this is, well, if this is a first draft, it's a good first draft. It needs some revisions. I'll leave it at that. I don't want to speak poorly of it. I'm just saying that it's not clearly thought through.
This is a first draft, but clearly very few things are going to fall into this. I mean, we're talking like the block, it's not the block, block one. What was that token? I think it was block one that did, what was it? You remember that one? Block one, SEC. They gave him the approval. No, sorry, not block one. Shit. What was that other one? Hey guys, help me out here. The one that used to be called Namecoin or Namecoin. Oh man, shit. Blockstack. Everything is a freaking block.
Right. I mean, you said block one, and all of a sudden I'm thinking OneCoin and Ruja or Ruja is going through my head.
And Blockstack, right? So it sounds like Blockstack. What Blockstack did is like the only thing that's fitting the definition of in that bill of the security.
Well, yeah, because they had some form of debt or equity interest, right, or voting rights. And I think no. There's another one that falls in there.
Plus. They were the first one to get the Reg A Plus approval.
Right. What was the? Damn it! It was a case like 3 years ago. There was an offering, and it had to do with airdrops.
And right, I remember that when they ruled the airdrops could also be.
Well, the airdrops can be securities if in the airdrop that the promised result is a digital asset that gives you some form of voting right and the promise of market participation. So at that point, that would qualify as crypto security because of an equity component, right? So that equity component is there because there were voting rights within the digital asset, which is similar or like to a stock or equity.
So in any case, so it feels like to me, like the use of the terms debt and equity here is very poorly phrased, as you pointed out, and right. Like Ethereum, EOS, and all of these ICOs on top of Ethereum are kind of in the gray zone. They're not defined here.
Well, hold on. So things that run on Ethereum, scroll up, I believe fall under the definition of rest on a blockchain under crypto commodity.
Well, see, that's the thing. The markets treat with no regard as to who produced the goods or services. And in a case of an ICO, that's a violation of Part B here.
So do you think Bitcoin falls under crypto commodity?
It does, under this definition.
It's not a good or service. It's not a derivative.
Well, again,
economic goods or services, including derivatives, that. So that doesn't include digital assets, right? That may or may not be fungible, that may or may not be speculative, that may or may not be property. I don't know what the definition of economic goods or services is here, because I don't think Bitcoin has ever been defined as an economic good or service.
Right, and goods or services are not defined. Also, this thing that says rests on a blockchain, I think that this is also a big mistake. A crypto commodity should itself be a blockchain, but the word blockchain needs to be thoroughly defined.
Right. So,
wait a minute.
But if you rest, it should say has its own or rests upon a blockchain to be all inclusive. right?
Well,
So
here's the thing: if you rest upon a blockchain, it's questionable whether you should be a crypto commodity. It's either going to be a cryptocurrency or a crypto security.
no, because that only includes stable coins.
Well, right. If you are on top of a blockchain and you are a stable coin, you are a cryptocurrency. And if you are an ICO,
and you're only a cryptocurrency if you are representing your stable coin in United States currency.
no, not necessarily. United States
The term
currency
cryptocurrency means
or
representations
synthetic.
of United States currency or synthetic derivatives resting on a blockchain or decentralized cryptographic ledger. What does that mean?
Well,
Synthetic derivative resting on a blockchain or decentralized cryptographic ledger.
Right. So the words decentralized cryptographic ledger are not defined. The word blockchain is not defined. And that's one of my biggest problems is that no one can actually define what a blockchain is, because you ask 10 people, you get 10 different definitions.
Oh, I don't know. I think everybody knows what a blockchain is. They just, the people that want to seem like they're cool and have something new to shill define a blockchain.
Well, wait, Jason, I guarantee that you and I will not come to a consensus on what a blockchain is.
Is a proof of stake chain a blockchain?
To me, it's not.
Correct. I agree. We just had agreement. You owe me a steak. You now owe me a steak. Are we done? I like mine medium rare.
Yeah, I'm losing steak bets everywhere. But here's the thing. I bet you that the consensus of people in the crypto space will disagree with us. And they will say that proof of stake is a blockchain.
I think what you have to do to begin with is to define and have an agreement upon what a blockchain is.
I agree.
Before you can analyze what proof of work and proof of stake chains do to determine whether or not they fall under that definition. So if you get into that conversation of, what is a blockchain, right? It is a decentralized consensus mechanism for the storage and preservation of data that is verified and re-verified
but wait a minute.
over time is a very generic definition, which you can still get multiple different interpretations.
Wait a minute. I'm sorry, Jason. This is a circular definition, because the definition of a blockchain is not supposed to use the word decentralized in it, because a blockchain is what creates decentralization. So if you use the word decentralized in your definition of a blockchain, what does decentralized mean? And the answer is a blockchain.
No. Let's say the same thing that I just did. A mechanism of storage of information, preservation over time. That's a database. The only difference between a database function and a blockchain is that a database is centralized and a blockchain is decentralized. Now, taking a blockchain one step further, in the initial deployment of what a blockchain is, you had some form of guarantee of structural integrity. And I'm going to say it, and I swore the next time that I said this, I was going to shoot somebody in the face with a shotgun.
Whoa, don't get my channel banned, Jason.
The Byzantine generals problem, right, of trust at doubles. Remember when all we talked about was Byzantine generals? God, I hated that.
It wasn't every white paper. We're solving the Byzantine generals problem.
Right, but the point being that in order to ensure trust within the data infrastructure, you had to have such mechanisms within that to be inherently a valid blockchain, relying upon the Merkle root style of public-private encryption. And to me, if you're not based on an original Merkle root style public-private key incorporation of data infrastructure and cryptography, if that's not your basis, that's not a true blockchain.
All right, so
it's just something else.
So on that note, he does define what.
Yeah, and I suppose that's like saying champagne only comes from France.
Right.
Right, and sparkling white can come from everywhere else.
Yeah. Hey, so while he doesn't define, or this bill doesn't define what a blockchain is, it tries to define what a decentralized cryptographic ledger is, using the word blockchain in this definition a lot. So while there's clearly gaps in what type of crypto assets there are, let's review the definition of decentralized cryptographic ledger. The term decentral.
Tone, I'm sorry. Go ahead and keep going. I have to type this email real quick, but I'll be right back. I'm sorry.
That's okay. I will entertain the audience with some a look at the price of Bitcoin, and then we'll get back. How much time you need?
2 minutes, maybe less.
Okay. Wow, that's a fast email. All right, I'm gonna switch over screen share, guys.
I type fast.
Let's see what the price of Bitcoin's doing, and then we'll get back to. All right, so here we are. Bitcoin is rising. Nice. This is a 4-hour chart here. We had our bullish price flip or bullish trend change according to the MRI indicator on the 4-hour chart. So we are all systems go here. This is a pretty bullish sign right there. I remain pretty optimistic on Bitcoin. We are about to close the day. I'm about to lose a third day in my Tone Vays pays for a very expensive steak dinner bet. And this would be, I was down 7 days. This would make it down 10 days if we close above 10,000. This looks like a very strong daily close. This yellow star will become a green star, meaning that it's very likely that there is gonna be a bull more upside. Now, of course, these stars don't always work out. You see one right here that didn't exactly go higher, and certainly this one, though one of these two should not have appeared. This code is still a little buggy, which is why it has not been released yet to the general public. Let's take a look at how the S&P 500 closed. And the S&P 500 closed very strong on the day. I remain pretty bullish. The S&P 500, I have no choice. The fundamentals don't really matter. And we have moving averages all rising. And we're challenging the recent swing high and going towards the all-time highs. Jason, anytime you're ready, just cut me off.
Yeah, no, I'm back. Keep going. You're fine.
Okay.
Or we can jump back in.
We can jump back in. Let's deal with how gold closed, and then we'll jump back in.
You know me, I'm a trader from long ago. I don't do day trading anymore, but it still fascinates me.
Whoa, look at gold. I have no idea what happened in the 1 hour that gold is closed in the, because futures market trade 23.5. So they trade 23 hours a day for 5 days straight. So whatever happened, oh, you know what happened? It's possible that the contract flipped. That's also possible because I'm looking at GS, the front future. So I do think that gold is topping here. I think the contract might have flipped over, but I don't have time to investigate that at this time. Okay, let's get back to the definition of crypto.
Of a blockchain.
Or blockchain. We really should have had our own independent show on this. Maybe maybe if you think about this some more, and we have other lawyers on, we can.
Well, I don't think necessarily other lawyers. I think what would be useful is to have, like Adam Back and Fluffy Pony, and those guys debate what a blockchain is. And because what would happen in a court of law is that the lawyers wouldn't get to decide what the definition is. They would have to bring experts in to advise the court on the components of what is or what isn't something. And then the court would have to decide what the definition is after hearing experts talk about it.
Right. Well, if you bring Charles Hoskinson in that discussion, he's going to argue that proof of stake is a blockchain.
Great, let's hear it. And let's cross-examine him and let's ask him why. That would be great television in my mind.
But that actually would be. Maybe I'll try to set that up, though I'm sure he hates me at this point. Let's take a look at his definition of decentralized cryptographic ledger. What is it? The term decentralized cryptographic ledger means a ledger that contains all of the following. That's
What's a standalone blockchain?
Runs as a standalone blockchain.
What's a standalone blockchain?
Okay. By the way, the guy who wrote this, we can have him on the show if you want.
But what does that mean?
Well, we got to bring him on. I'll tell you what I think it means. What I think it means is it's not on top of another blockchain. So it's Ethereum is a standalone blockchain. So is Litecoin. So is Bitcoin, obviously. And you and I don't believe that Cardano is a blockchain because it's proof of stake. But if Cardano is defined as a blockchain, then Cardano would be it. But
hold on. Let me ask you a question here. When Bitcoin hits 21 million, it's no longer minting, but it's still a proof of work system. Is it no longer a blockchain when Bitcoin hits 21 million? Problem here?
That's a very good question, but that's not going to happen for another 100. But wait a minute, but Jason, that's not going to happen for another 100 years.
I don't care. There's other quote blockchains out there that are doing proof of stake that don't do minting functions.
But they're not. But we just said they're not blockchains if they're proof of stake.
I don't know, but his definition includes proof of stake.
I know, which is but you're arguing what does standalone mean, and I'm trying.
Correct.
Right, but to me, standalone means that it's not dependent on another decentralized cryptographic ledger, because he's trying to define a decentralized cryptographic ledger. So something like the Binance token is not. Now, here's the question, because he does say—
Do you know what I don't see here is what defines decentralized?
Well, I know that's the other problem here, because—
that's why I got hung up on standalone.
Right.
Standalone, is it one computer? Because if it's one computer, it's not, I mean, that's standalone, but it's not decentralized. What determines the definition of decentralized? How many friggin' nodes do there have to be?
Oh, wait. So remember, but Jason,
apart from each other.
I know, but Jason, remember, a decentralized cryptographic ledger is A through H. It has to be all of them. So you may not get your answer here, but you may have a clear picture when we finish.
I read ahead.
Okay, so anyway, I want to finish. I have not. Well, I've read all of this already, but I'm reading it for the audience because this may or may not be in audio form. I don't even know anymore if my audio podcast still exists. Runs as a standalone blockchain that is secured through a mining mechanism.
Minting
mechanism, such as proof of work, proof of stake, or otherwise. So there has to be a minting of the coins. So Ripple doesn't fit because they just created all of them from the start. But again, the word standalone is interesting because, again, I'm going to go back to Cardano. Cardano's token, ADA, was an ERC20 on top of Ethereum. So what the hell is that?
I don't know.
Okay, so let's move on. Runs as a cryptographic asset or smart contract on an existing stand. So I guess it's or, because these two are contradictory. Runs as a cryptographic asset or smart contract on an existing standalone blockchain and is secured through the issuing blockchain minting mechanism.
Okay, so in general statutory construction, the way that this is put together with semicolons at the end of each section. Mm-hmm. So section A has a semicolon at the end of it, right?
Mm-hmm.
Generally, that means, unless it says or, the default is and.
That's what I assumed.
Okay, so you can have ands and you can have ors, but if there's no ands or ors, then every sentence is an and. So
that's how I assumed it, but now that I'm reading A and B carefully, they seem to be contradicting each other.
Well, no. They don't contradict each other. They improperly include the smart contract on top of an existing chain.
Right.
Right? Because I don't know how a decentralized cryptographic ledger can be a smart contract on a ledger.
Right.
How do you have a ledger on top of a ledger? Is there an example of that?
Sure. Again, the Cardano's ADA token on top of Ethereum servicing the Cardano proof of stake blockchain. Or something like MakerDAI, which is which is that decentralized what do you call it? Lending thing, or whatever the hell the DAI is doing. So it's rests fully on top of Ethereum.
But at that point, you can't have an individualized proof of work on top of, can you have an ERC20 token machine that is a ledger that also has its own individual proof of work or proof of stake mechanism within it?
Yes. Who
does that?
What?
Who does that?
Cardano.
Cardano has proof of work on top of proof of work?
Proof of stake on top of proof of work. So, the Cardano token is an when was ADA? Is the ADA not an ERC20, guys? I thought it was. I gotta double check that. Hold on. Is ADA an ERC20 token? I thought it was.
And to answer your audience's question as to whether or not I have a clue, I have a clue about some things, but I don't keep up with the thousands of shitcoins and how they work.
Token. Okay, so it is on its own blockchain. Okay, so I'm wrong on that one. So ADA is not an ERC20, but ADA token tracker on Etherscan. Cardano to launch ERC20 converter. There it is. Top Ethereum ERC20 tokens. I can swear that it was. They might have converted it.
Well, we're digging into the minutia, which isn't really necessary at this point. I think what's relevant at this point is looking at this proposed bill and recognizing that it really fails for ambiguity and lack of specificity to be able to be passed into law, and that's the
Anyway, you're right. So Cardano might not have been. I mean, look, like all of these things are like outright scams anyway. But so look, if we start digging into it, I guarantee you there were ERC20 tokens that you can then stake and create more tokens after. Oh, here it is. Someone is telling me ADA launched as an ERC20 token and then did a coin swap to their own network, kind of like EOS. There you go. I knew it. I knew it was an ERC20.
You know more than I do at this point.
Anyway, so you're right. I mean, let me just finish reading this. Is immutable, so Ethereum's out, because it's proven.
The DAO, it's not immutable. We had the DAO for it, right?
Yeah. Right. So like that, this takes out Ethereum.
So by definition, Ethereum is not a decentralized cryptographic ledger.
Right. Is immutable and cannot be overwritten without controlling a majority stake of the associated network. But then how is it decentralized?
No, this is stupid, because is immutable and cannot be overwritten without controlling a majority stake. So what they're talking about there is the 51% problem, right? That's a 51% issue.
Yeah. But
so I understand where that's coming from, but to the extent that if you have two people that are participating and there's only two people with nodes, neither one of them will ever have 51%. It's 50-50. you're telling me that a two-person, two-node network is decentralized, and I'm going to drop a bollock. This just doesn't work, right? Nobody would say that a two-node chain is decentralized because it's just.
All right. So let's move on. And remember, these are all potentially ands. Required.
They're all ands. The way that it's written under statutory construction, these are all ands.
Requires a cryptographic link between blocks of transactional data. That sounds more like a basic definition of this stuff. Is permissionless, requiring no third party to transact, only a connection to the internet. Is an irreversible bearer commodity with all transactions being final. Again, Ethereum proved this to be wrong, or Ethereum proved they're not a decentralized cryptographic ledger. Is not controllable by any one single entity, defined as having less than half of all nodes controlled by one single entity. And yeah, so they were all ands, the final and right there. And is not directly issued by a nation state or private entity. So every ICO is out. So because every single ICO is directly issued by a private entity. So what's
registered in Zug?
Yeah.
They're all registered in Zug, Switzerland.
But here's the thing, right? It's saying is not controllable by any one single entity, defined as having less than half of all nodes controlled by one single entity. So this means that if you have more than 51% of the nodes in control, you can still be considered a decentralized cryptographic ledger, right?
Yeah, this is a train wreck, is what this is. But it's not easy to write legislation, right?
Oh, I agree.
But that's why legislation and laws are hard, because you have to consider every single thing that every single person is going to look at and dice around. And that's why drafting new law is a very lengthy process and goes to committees and out of committees and back to drafting committees, and you have revisions. So it's you know, making new laws is hard. It's tough work.
So anyway, so this goes now, then it tries to define where a decentralized oracle is. And I told them, I don't believe a decentralized oracle even exists and never will.
What is an oracle?
An oracle is something that tells you the outcome. So for example, ESPN.
A springing contract event to trigger a smart contract payment?
I mean, an oracle is something that tells you an outcome. So like ESPN is the sports oracle we trust. So if you want to know who won the game, you go to ESPN, and ESPN is your oracle on who won that game. So a decentralized oracle tries to...
It's an agreed upon third party objective source of information.
Not really, right? Because it's not supposed to be a third party. So there is a third party that's supposed to build a decentralized oracle that doesn't rely on any third party, and it like pools information in order to come up with the best answer. So basically, someone will make the argument that you can't trust ESPN in knowing who won that football game, so you have to rely on something like Chainlink to do it for you.
Okay, moving on.
Right. So a decentralized oracle, the term decentralized oracle means a service that sends and verifies real-world data from external sources outside of a blockchain and submits such information to smart contracts that rest on the blockchain, thus triggering the execution of predefined functions of the smart contract.
Yeah, the only reason you need an oracle is for smart contract resolution and distribution of assets, or settling a bet, like you owe me a stake.
Anyway, we have a bunch of other definitions here, but here's the other part you might like. So if we go back to our three definitions of crypto commodity, cryptocurrency, and crypto security, he defines, or this bill defines, who should regulate these things. And
Definition 6, digital asset means a crypto commodity, cryptocurrency, or crypto security.
they're all digital assets. Yeah.
Right. So the primary federal digital asset regulator is the CFTC.
For crypto commodities.
Uh-huh.
And it's the Treasury and FinCEN for cryptocurrencies, and it's the SEC for crypto securities.
Right, but what they've effectively done is created a definition of a crypto security that means that nothing is ever going to be a crypto security.
Yeah, that's what it feels like. Well, it could be if you file the paperwork with the SEC claiming your debt or equity. Otherwise, you're in this gray zone that this bill doesn't address at all. And we still don't know what Ethereum is because it fails on many counts of the definition of a decentralized cryptographic ledger.
Yeah, it's kind of to stop the bleeding on this topic. This needs to be rewritten. It just needs to be rewritten. Has this been submitted? Did somebody actually submit this? Is there a sponsor to this bill?
Yeah.
Who sponsored this bill?
Good question. Let me see. It's on the government website.
Yeah, there should be a sponsor. Gozer. Okay. Didn't Gozer just come down with Corona at the hearings yesterday?
I have no idea. I haven't turned on TV in forever.
Yeah. Gonna need to send him a message.
Is he in Arizona? Okay. Yeah, so look, this has been out there for a while. We really should have gotten to it a few months ago. Yeah. And if you want, I can have the Marshall Hayner, who is responsible for this, on our show, and we can talk about it with him, if you like.
Yeah, that'd be great. Let's do it.
Okay, I'll reach out to him. Yeah, because like a lot of this stuff is insane.
Well, I think it's just not refined is all. And,
all right, guys.
Yeah.
We've gone 3 hours or close to it, and I think it is time to call it a day.
Well, let's open up the forum just briefly for any questions on any of the subject matter. Give like 5-10 minutes of Q&A. There's a lot of things that we covered without really allowing for some Q&A. What do you think? Is that all right?
I'm okay with that. Guys, throw in your questions. We're down to about 150 live viewers.
I'm waiting for something out of the troll box. Like,
yeah, but it's kind of like a 60-second delay, so they probably haven't even heard us ask for public comment. We have a quote.
Well, that's a callback quote to our discussion at the beginning of the day about what anarchy is. Oh, you're welcome to Crypto Zorro. It was a fun time. Do I use onboard reverb? Are you talking about in my Fender amplifier back there? No. I'm a purist. I use a spring reverb instead. I like a spring reverb. And so what I'll do is I'll bring the old spring reverb stuffs out of actually a Marshall 8080 valve state amp and put it in line with that before I process it. Good question.
Hey, so people are asking us about Tether. I don't know if you're up to speed on that. I think we're gonna try and do another show really soon because I have a bunch of topics, Tether being one of them, Ripple being another, yeah. So we're gonna do another show. I'll try to get some other lawyers on here because Tether is an interesting case as to what's going on.
Question about the Baja 1000. The plan is to run the Baja 1000, but right now there's questions of whether or not the Mexican-U.S. border is going to stay open to allow us to travel down into Ensenada and take the race car down there. Hope we can. I'd love to. I'd love to have the opportunity to run the car down there and have some fun. Yeah. My opinion on people using SBA loans to purchase Bitcoin, I think that's fraud. The reason for the SBA loans wasn't for speculation on cryptocurrency. It was to keep businesses open, employees hired, doors open, things like that, and to buy cryptocurrency with SBA funds, I think is it's a fraud on the taxpayer to do that.
Well, but it's not just crypto, right? I mean, taking it and buying Apple stock with it is the same thing.
Correct, exactly. Or taking it and buying a luxury car is the same thing.
It's not a crypto issue. It's you're getting the money to do X. If you do something else with it, that's fraud.
Yeah, well, and it's fraud on the taxpayer, right? I mean, we're pumping trillions of dollars into the economy to try to survive the COVID crisis, which effectively is a socialist safety net, right? And if we're going to do that, then it should be used for food and bills and car insurance or things like that, not for speculative investment.
So they're saying, how does the New York Attorney General have jurisdiction over the Tether case? Well, they're basically saying that some of the Tether users are New York residents, and users of Bitfinex are New York residents, and therefore New York has authority to go after Tether.
What they may also say, and I haven't read it to the detail that I'd like, is that what a lot of agencies in New York like to do is say that New York is the banking capital of the world, and it's more likely than not that transactions that may have include wiring money went through servers located in New York, and therefore, because those transactions that went through a global monetary system most likely went through New York, that New York has jurisdiction. I've seen agencies use that excuse before. I don't think we need to take that question. Maybe another question. Give it a couple more minutes. We could talk about how your meat supply is holding up, Tone. Are you running out of protein meats?
You know, my fridge isn't as stacked as it used to be, but the farmers markets are open, and I don't like stacking meat in the freezer for too long. I like it like still fresh-ish. So yeah, so I'm doing okay. As long as
Costco has a very good organic beef option that comes in a 3-pound pack.
Yeah, but I buy that from my farmer as well, so I know exactly. Like, I've been to the farm, so I know where I'm buying my stuff from. That's where I buy all my meat. All my fish is also fairly fresh. So that's why I try to stack up on. That's pretty much all I eat. Meat, fish, eggs, and fruits. That's it. That's the list.
I started running again this week and put in 3 miles. It's been a while since I'd run, and my activity level has been so low because it's so hot here in Houston that going out and running means you're going out and running in 90 degrees and 100% humidity at 8 o'clock in the morning. And it's just tough to stay active. But I did, and instantly my body went back into my old running mode. And even though I'd only burned maybe 800 activity calories, I think I probably took in 3,000 calories of like pasta and meat and everything else over the next couple of days. And I have to remember when I'm working out and when I'm doing those things to avoid pastas. The carbs are just, don't want to turn out to be a fatty, like David Silver. What? Did you just say that? Did that just happen? What?
No, he's not going to watch the show. All right, guys. Hey, thanks for hanging out with us. We'll try to bring you another show in a week or two, hopefully sooner than later, so we can cover the other interesting topics. And I'll try to get Marshall on here, who's helped write that bill, so we can dig into it a little bit more, because if that thing passes, it's going to be interesting.
Well, what I would like, if I can put in a request, is maybe put out a survey to your viewers of what would they rather see? Would they rather see programmers and experts in the cryptocurrency industry debating on the definition of a blockchain under cross-examination from lawyers to tool out what that definition is? Or would they rather see a bill?
Well, everybody would rather, I mean, that's easy. I don't have to poll the audience. Everyone would rather see the former, but the former is going to be challenging. So I can try to set that up.
You can do it. I mean, let's get Jimmy Song on, right? And then ask Jimmy Song to bring anybody that he thinks can back his play. And that's going to be the proof of work side. And then let's find a proof of stake advocate, right? And let's get a proof of work and proof of stake people up here and have them debate why they're both blockchains. And let's just watch it fly. We don't even need to have everybody else on. Hell, I'd love to host that myself, but you have the contacts now. You're on top of the mountain. You've been to the top of the mountain, right?
It's going to be.
Remember when everybody talked about, have you read the white paper? Have you been to the mountain? Right.
It's going to be really challenging for me to keep my mouth shut and let the experts speak on that one, but I'll do my best.
You can always mute yourself.
Yeah.
It's times like this.
I may have to give hosting permission to someone else who would actually mute me.
Seriously, it's times like this. I miss the resources of the old dojo.
Yeah.
Right? Everybody was in the dojo, and then maybe your viewers don't know what the dojo was. That's okay.
A few of the viewers, I think. I don't know if anyone was in the old dojo, but I don't think it still exists. I think I'm out of it.
No, the old dojo was deleted because Chris DeRose refused to stop posting racially charged hate messages that were attacking other people. And he was warned multiple times. And one of the rules of the dojo was that no one would ever be banned. And if it ever came to the point that somebody needed to be banned, instead of banning one person, the dojo would be deleted. And that was always the goal, to kind of check yourself and not be a dick in the dojo. And Chris refused to stop. And so the dojo died.
So was he the one that was posting those messages, or he refused to ban people that were posting them?
No, DeRose was posting those messages.
Right. Yeah. So whatever happened to DeRose? Is he gone? He's gone, right?
The last time I talked to him was maybe a year and a half ago when I did that small interview with him about Bitcoin being a storage of value was bullshit. And then shortly after that, Junseth and I were working on a few different things, and then I just wasn't dealing with Chris anymore. Some of the things that Chris was engaged in or involved with just kind of fell outside our realm of what we wanted to do, right?
Yeah.
And as Bitcoin Khaleesi points out, Adela, sorry you missed the conversation.
Adela,
I missed the old Chris as well. The old Chris was cool. New Chris is, I think he's lost his way a little bit. But if his new way is the path that he wants, then God bless him for finding his path. We don't all have to walk the same path all the time. So.
But yeah, so I blocked him on Twitter like a year or two ago, so I have no idea if he's even like tweeting or anything. So I have no idea.
Yeah, he ended up wanting, when he left Bitcoin Uncensored, and this is just a little bit of Bitcoin history, my interpretation of it, I'm sure there's a different truth, but when he left Bitcoin Uncensored, he went off to Thailand for a while, had some life experiences there, came back, wanted to be considered some form of legitimate journalist, and then went and embedded himself in some really interesting white supremacist type protests as an embedded reporter, and got heavily involved in that. And then from there, things just took a different turn. They took a different turn. He went down a different path. I'm not here to judge. That's all.
I will say, like, if my memory serves me right, he was on that Thailand spiritual vacation while the show was still around, and then he came back.
And it all blew up. It all blew up. Yeah.
Right, the show still lasted for a few months after he came back, and then it all blew up.
No, it really, truth be told, it blew up before he left. It was just, it was a long death. Yeah. It
was like the show was still running, but it was pretty much over. But yeah. That was a good point.
And really, out of that is when my show really started, because I was looking to fill the void of the content and to start to provide content.
Oh yeah. Oh, I took a lot of their audience. Basically, half their audience went over to my content. I was doing the crypto scam episodes and interviews at the time that were similar-ish. So I definitely picked up a lot of that content. But yeah.
I mean, I was doing more Ask Me Anything Q&A stuffs on Sunday mornings, and just kind of being a pro bono lawyer.
I remember those. That was good. You still have the YouTube channel too. All right, guys.
Yep. Anyway,
time for us to get going. Thank you all so much for watching, and I will see all of you at some point tomorrow for another price show and maybe a news show later in the week. Thank you all for hanging in with us for over 3 hours, and I will see you all on the next one.